Kia ora te marina, kia whakapapa punama te moana. E tuarahi mā tatu I te rangi nai. Aroha atu, aroha mai, tatu, tatu katoa. Hui e, taiki e. Welcome everyone to this hearing. Trust everyone can hear me okay. I welcome everybody who's listening online and people in the room today. This hearing is being recorded and live streamed. This is a hearing of the application by Big Units Limited for a 6-unit development at 9 to 11 Perium Place, Isa Moorings. My name is Gary Ray. I'm chairing this panel appointed by Central Otago District Council to hear permission to make a decision on the application. I'm an RMA planner and independent hearing commissioner with chairing accreditation, a fellow member of the NZBI based in Tasman District. I've done about 20 hearings in this district, so reasonably familiar with the environment here. I'll ask my fellow commissioner to introduce himself now.
Morena koutou. My name is Ros Day Given. I'm an independent planning consultant appointed as an independent commissioner for this hearing. I'm based in Aotearoa, Dunedin.
Thank you. Now, I'll call you Ros for simplicity. Ros and I have worked together on several hearings in this district. One of those hearings was Parkburn Estate, which is on the site next door, well, pretty well next door to this site, so we're reasonably familiar with it. And I've also stayed in the Marsden Lake Resort a few times, so I'm reasonably familiar. Ros and I both went up to the site yesterday to have a familiarisation visit, and we walked around the site, and we may well go back there at the conclusion of the hearing if we need to follow up on some matters that have been raised through submissions. Okay, in terms of this hearing, it's been quite a process to get in the room today. I'll have to acknowledge that. There's been a bit of chopping and changing. Amended plans have been lodged, but I think the key thing is, as commissioners, we've endeavoured to make sure everybody's aware of changes that are made and has been able to comment on those changes. And we're here today, and we will discuss the amended plans. As a result of that, there are a number of statements we have to consider. So please forgive us if we have to chop and change back to our files to find the correct statements, because I think there's evidence in chief, supplementary statements, and now summary statements as well. That's all fine, but we will need to pause at times to find those documents. So, thank you. And I do believe we have some larger prints of the application plans coming for the panel. They've been printed, is that right? Just to make it easier for us to understand Mr. Weir's presentation when he comes on. But other than that, we're all geared to go. As commissioners, we've read all the material and we have questions. We don't expect people to read their statements out unless we ask you to, but for the summary statements. But we do have a number of questions which we will ask. And the same goes for the lay submitters, who I think we've got 3 on this afternoon. We'll have a number of questions for those submitters, even if they don't have additional statements, previous submissions. Right, we're just about there. In terms of the process, there's a hearing schedule that you will have been sent. Basically, we start with the applicant's team, and that'll take us through to lunchtime, we expect. And then after lunch, we have 3 submitters who each have 15 minutes each. So we're going to finish relatively early this afternoon, but that's a chance for the panel to go back to the site. Or if anyone who's on day 2 wants to come forward, they're welcome to, but I understand arrangements have been made to come on the following day. So you'll hear from the represented submitters, if you like, and then we'll hear from the council reporting team. So we'll have Duncan White, Rachel Eaton, Urban Design, and Dominic Honan, Environmental Engineer, will be in attendance as well. And then we'll go back to Mr. Gardner Hopkins, who's the project manager advisor for the applicant, who can sum up any verbal matters he wishes to be followed up by a written reply later on. So that's the general order of proceedings, but we are flexible if the need arises. So we'll see how we go with that. Thank you. And finally, just in terms of health and safety for those in the room, in an emergency, we exit through those doors, turn hard left, and go through to another door which exits onto a reserve. Is that correct? Onto a grassed area outside. if that should happen. And just before we go any further, does anyone have any process issues or any matters they wish to raise at the start of the hearing? Otherwise, I'll proceed. And I should also introduce the council admin team, which Taryn Lyons, who's the person mainly responsible for organising the hearing and the material to be distributed. We've also got Karen Smith, who's assisting with that as well. So these two ladies have got control of everything that's going on. So it's very good. All right. There appear to be no questions, so we'll go over to Mr. Gardner-Hopkins, who I see is online. Welcome, James.
Thank you.
And thank you very much for lodging your submissions. We understand you had a family bereavement, and our condolences on that, but we have read your representations and understand those that have a number of questions. So I'll hand over to you, but we welcome you to read them to us if you wish. Yeah.
Thank you. And look, I don't usually read out my submissions verbatim. So look, I really just intend to talk to the key points. And look, I appreciate the opportunity to present to you remotely. If it would have been my preference to be in the room, but I've had some travel as well, which just meant it wasn't possible to make it down in person. And I think the last thing that anybody wanted was to try and rearrange another date. So look, I'm here virtually, and look, unless you wanted me to introduce the team at the outset or to have them introduce themselves, I'm happy to just launch into taking you through the highlights of my representation.
Yeah, look, I think you could just launch straight into it. I think we know many of your team, so we'll come to them at the right times. I think you just launch into it. Yes.
Excellent. Well, look, as I say, it's not intended to read them out verbatim, and I understand that you have had the chance to read them. So look, if I do my highlights package, as it were, if there are questions on the way or towards the end or at the end, I'm in your hands as to how you would prefer to approach that.
Yeah, we'll do it at the end, James. Yeah,
Okay.
We'll do questions at the end. Yes.
Okay, excellent. Well, look, I guess just by way of opening, we've obviously got two quite divergent views in terms of this application, its effects, its appropriateness, in terms of the applicant and to a very large extent the council's reporting team and the submitters, and for those who are represented, their lawyers and their planners. And look, that's not unusual. In my mind, the greatest difference probably comes in the emphasis on the proposed district plan provisions that now exist, and the application of I guess the rule framework that establishes. And I'll get into that in a little bit, but I see that as one of the fundamental reasons that I guess there are these two differences in both expert and I guess sort of legal or other opinions. And I guess I may as well keep going on this whilst I'm talking. The reality is that this was lodged some time ago. And look, rightly or wrongly, the framework of the RMA has allowed that to continue to be processed under the activity status that the consent was lodged under the ODP. And there appears to be almost consensus, and I say almost, that activity status is restricted discretionary. Now, I say almost because I think counsel for one of the submitters, Mr. Greason, has put a submission in that suggests the activity may well be discretionary, and that's because of how the site coverage might be calculated. But he also goes on to say that it may not actually make much difference because the key effects in issue are all captured by the matters reserved for discretion. So, if you like, it might be a technical point, but as I understand his submission, it probably doesn't make any difference. I would say, and certainly the applicant's planner and the reporting planner both take the view that it is restricted discretionary, and I think you can safely proceed on that basis. And I suppose one reason that I'm starting off with this is because that does set the framework for your assessment. In my written submissions or representations, I should probably say, I had set out a comparison between the matters reserved for discretion under the PDP and the matters reserved for discretion under the ODP. And they're not precisely aligned, but again, they essentially cover the same field. And so there is a question as to, well, how do you take into account any matters of discretion in the proposed district plan in your decision making? Because of course the consent status is crystallized. It has to retain restricted discretionary status. It can't become non-complying or what it might otherwise be if it had been lodged under the operative district plan. So it remains restricted discretionary, and there could be a question as to, okay, if there are additional matters reserved for discretion in the PDP, should they also be considered in the consenting process? Now, again, this I think is one of those questions that is of little practical moment, because although they're expressed slightly differently, they essentially also cover the same ground. So I guess what I'm saying is it's another issue that in perhaps different circumstances, if the PDP had introduced an entirely new matter for discretion that was new and different, you might have to decide, do we have to apply that as a consent requirement in this process? And what I'm saying is that issue doesn't arise here. The technical position I take is that it is consent under the operative district plan that is required here, and that is all that is required here. And so your framework, your focal point are those matters reserved for discretion under the operative district plan at the time that the application was lodged and accepted. And so where does that then get us in terms of the relevance of the proposed district plan? And I say it is principally relevant in terms of the objectives and policies that it has proposed. And there's not quite the same need for objectives and policies to distinguish whether they're fully operative or operative in effect or the like. Unlike rules which have their own sort of regime, a proposed objective and policy becomes relevant from the time that it is proposed. So I accept, and you do need to have regard to those objectives and policies, but what I would say is they have to relate to or address a matter reserved for discretion. And so that is still your sort of focal point. But again, a number of those matters reserved for discretion are quite wide and talk about amenity and those sorts of issues. And so policies that address amenity are entirely appropriate to take into account. The other matter, and I am not entirely sure if I addressed it in my written representations, but it flows from this, and it flows from the issue as to weight. And it's, won't say it's complicated, but the approach to weight often is taken in quite a sort of loose or informal way. The authority, and I do recall I didn't put it in my written representations, and I may have to email it through. I think it's one of the early either body corporate or Bailey cases that identifies when you have a operative plan and a proposed plan, you ordinarily, if you were applying for consent, would seek consent under both. And those cases established that the correct procedural way to approach that is to look at, would you grant consent under the operative plan? And then would you grant consent under the proposed plan? And if you had the same outcome under both, if you like, consents, then the issue of weighting doesn't need to arise. It's only if you were to grant consent under one and not grant consent under the other that you then would need to determine which has greater weight. And so the situation, I say, is a little different here because we are only seeking and only needing consent under the operative plan, because that has crystallized under Section 88A. So it really comes down to under 104D, and the matters for you to have regard to, obviously effects, relevant planning instruments, and so that is where you are entitled to look at the objectives and policies of the proposed plan. And in that context, you do need to resolve how important are they, how influential are they, and how do they factor in to the decision you have to make. So that's just I guess, my scene setting in terms of how I see your analytical framework in terms of decision making, at least in terms of activity status and then relevance of the PDP.
Thank you. So should we just ask you some questions now and see where that goes?
Look, on those issues, that's probably sensible. Yeah. Yes, please do.
We'll do that. Yeah, thank you for that. And it would be useful to have your verbal presentation sort of committed to writing in the right of reply if that can be arranged, because it would be useful to hear it expressed in that way. Because as commissioners, we are grappling a little bit with this issue. We understand that there have been appeals lodged on PC19 by one party, and those appeals relate to the key residential density standard, but also I think policy 6, which relates to density as well. But there is an objective, and I think it's objective 2, which talks about low density, low density living environment. It anticipates a low density living environment, so that if our first observation is that if the appeal is successful, for instance, the objective sort of would be a bit incongruous with the relaxation of the policies and rules further down the line. And we've also been told by counsel for the submitters that it's a site-specific appeal, but it appears to me that it would affect the whole plan change, in terms of the policies and the standard which apply to all sites. So we need to ask questions of the witnesses on that as we go through. But just to go back to your presentation earlier, we understand that the objectives and policies from your submission as when they were notified, they have immediate relevance, I think you said. And
Yes.
whereas the rules don't necessarily, if they're subject to appeal, we have to consider that in our weighting. But I was just going to ask you to tell us again about what weight can we put on the objectives and policies, even though one of them is subject to appeal.
Yes. So I guess coming back to my first point, they are a matter for consideration under Section 104. The weight that you give them will be dependent on a number of factors. And one of them, as you rightly identify, is, are they beyond challenge?
Yeah.
And so to the extent that a policy is under challenge, then you would be entitled to give it less weight. And as is often the case, decisions are made in a state of planning flux, and with changes, or potential changes in the mix. And in a way, you have to do the best you can, but you wouldn't treat it as, if you like, ironclad, if it is still subject to an appeal.
Right, and thank you for that. And just to go back to the point I had earlier, the LLRZ02, Objective 2, appears not to be under appeal, and that refers to a low-density living environment as an expectation. So would it be reasonable for us to assume that is the framework? It's to be a low-density living environment.
Yes, but I guess this is one of the difficulties, because that is in the context of a zone and a rule framework that does not apply here, at least in a strict sense, because this is to be heard and determined under the operative plan and under the relevant rule triggers that have generated the requirement for consent. So that it is quite complex. So you can't disregard the direction of travel, if you like, or of the PDP. But I would say it would be at risk of error to give too much weight to the PDP and override, therefore, the operative plan, which is what consent is required under.
Yeah,
that's the complexity here. That's the tension.
I understand that. I'll just hand over to fellow Commissioner at this point.
Yes. There's one question from me, just so that I'm clear, and it no doubt follows on from the conversation you've just had with Commissioner Ray. In your verbal representations, you said that the policies relating to amenity are of relevance to us.
Yes.
And I wanted to make sure I understood that correctly. Were you saying that the other policies are not relevant, or was that just an example of
that was an example? Okay. I guess, and what I think I also said was the policies and objectives that are relevant must relate to the matters reserved for discretion.
Thank you.
And so amenity values are one of them. I think they're off the top of my head in terms of matters reserved for discretion. There's the natural character of water bodies and their margins. There's the safe and efficient operation of the roading network. And there may be one or two others. But an objective or policy, I say, in order to be able to be taken into account, must relate to one of those matters reserved for discretion.
Thank you.
I think that's all the questions we had on those overriding things. Is there anything else you wanted to address us on in your presentation or representations?
Look, not a huge amount. And that discussion's been useful, because I do think that's one of the most difficult things for you to grapple with. I think the evidence on sort of most of the substantive matters is relatively straightforward. But look, just I guess on evidence, and in fairness to the represented parties, just a point I wished to make was that you may need to take some care in how much weight you give their planning evidence. And I say that because their planning evidence doesn't draw on any support from a specialist urban design expert. So they're simply giving evidence as a planner and opining on certain urban design matters. And look, planners are generalists. They are capable of giving opinions on a wide range of matters. But what I would say is that the planner for the applicant draws and acknowledges the evidence of Mr. Weir, the urban designer for the applicant, and in a similar way, the reporting planner relies on the council's urban design specialist as well. And I'm happy to be corrected, but the two planners called by the represented submitters don't seem to acknowledge the specialist urban advice that both the council and the applicant has received, and explain why they effectively have ignored or set aside that advice. And so to that extent, that they aren't relying on a specialist, and I just wished to make that point. I think it is something for you to consider, but I wanted to raise it at the outset so that the council for those submitters could address it if they wished.
All right, thank you. I have a couple of other questions which I'll ask you now.
Yes.
The urban design aspects, I was just going to ask you, it appears from my first reading of all of the urban design evidence, especially the peer review by council's expert, that the urban design goes into a fair amount of what I might call internal design aspects, orientation about the living areas, internal privacy between units within the complex, and landscaping and things like that. Is the applicant satisfied that those are all valid matters under the RDA criteria? Have you taken the approach that they are valid and that you'll respond to them, or is there some sort of pushback at all, do you think, in terms of what's prescribed as the assessment matters?
Yes. Look, and it may be that either the applicant's planner and urban designer can talk to this, but I certainly took the view that the matters reserved for discretion were sufficiently wide to incorporate internal, if you like, amenity, as well as external amenity for neighbouring sites, privacy and the like. And look, the reality is, the applicant wishes to have a quality development for those who are living there, and respond appropriately to the wider neighbourhood and its amenity.
Right, now that's useful to know, because that might determine how in depth we go with questioning on that aspect. But thank you for that. Another question I had was about the net area definition. There's been some discussion about whether a rear allotment, a rear site and allotment should be rear allotment and rear site. And I must declare that that's the way I've always interpreted it as a practicing planner over many years, that those discussions about excluding access generally apply to rear sites. But we're obviously open to evidence on that, but that's the approach you've taken, and I think that's the approach that 42A officer has, and your own planner. Did you wish to comment on that in further?
Correct. And look, in simple terms, we take the view that if you were to apply it any other way, the rule doesn't really make sense, or the definition doesn't really make sense. So we think it's both a practical and also textual interpretation, and we think it really is a plain and ordinary meaning. You can get into whether there should be a comma, or if there wasn't a comma, does it change the meaning? But I think you have to apply that word rear to both rear site and rear allotment.
Yes, and I guess the worst that could happen if we accepted the evidence to the contrary would be that the coverage calculation would be higher than it would otherwise be, because you exclude those areas. And what would be is that a matter of scale and degree, or is that a fundamental problem, do you think, if we were to apply that?
No, I think it's a matter of scale and degree, because in reality, it would be the same proposal that's being assessed. And
Sure.
The substance of whether it is appropriate or what the effects are is the same. I think technically, and this is I think the point that Mr. Greason was making, that would trigger, if you took the alternative interpretive approach, that would trigger discretionary status. But he then, as I emphasized earlier on, then went on to say, well, it probably doesn't matter, because the key effects at issue are already within the matters reserved for discretion in any event. Okay. So yes, it's not something I think that is fundamental to resolve, but I think certainly from our perspective, the correct interpretation gives a site coverage that doesn't trigger discretionary status.
Thanks for that. And I just thought of another thing, the 15-metre yard setback, there was some discussion about that. And I think I'm right in saying that the planners all accept that the 15-metre yard applies to the property boundary that adjoins the lake, not right to the lake edge. And the implications of complying fully with all yard requirements would be a much less intensive development on the site. I'm not sure it'd be 3 units maybe, or something in that order, but it would have a big impact, would it not, on the...
Yes.
For the site to be developed.
Yes, yep. Yes, and the view that we take is that the 15-metre boundary setback is effectively a trigger for assessment. Yes. And so the effects of any intrusion into that boundary then get assessed on their merits. And I suppose, and that's going to be contextual or site specific. And so where there is a margin, sort of a lake margin beyond the property boundary, then the effects of encroachment into that boundary, we say, are less than if the boundary was hard up against the lake edge. So that's what we say, and we also say that it's not it doesn't render development within that setback prohibited. It doesn't trigger non-complying status. It simply triggers restricted discretionary status.
Yeah, understand.
Yes.
I understand that point. Just as a follow-up, the 15-metre that applies adjacent to boundaries adjacent to the lake, I'm trying to understand whether the drafters of the plan might have anticipated that there is a buffer on top of that, or whether it's a boundary that applies. In other words, the point you make about mitigation being the extra buffer to the lake, would that already have been included in the 15-metre rule as an anticipated outcome? In other words, we should have discounted in that way. You know, you probably won't know the answer to that, but it's something.
No, and there may not be an answer, but as I understand it, from a practical perspective, there are varying circumstances where sometimes there is a lake margin of varying widths. It's not a standard 20-metre width, you know, everywhere around the lake margin. And so in some cases, there are boundaries that are closer or on the lake edge. And so I think that comes back to, it is a trigger, and then the consequences or the effects of triggering that assessment need to be taken into account.
Sure. Thank you. In terms of scope, your legal, the submissions you've said have basically said that you don't consider there to be any scope issues.
Yes.
And now we've talked through one of the planning evidence around the rule breach triggering full discretionary. So you've talked through that. I think I'm clear on your position on that.
If I could just pause there, and it is potentially relevant for scope, that the authorities more recently at least have focused on the scope being what the project is, rather than necessarily what particular rules are triggered. And so consent is granted for an activity. And so in terms of what is the scope of that activity, it is what was applied for, and are any modifications broadly within what was applied for. So I just wanted to say, I don't think, even if you found that it was discretionary, I don't think that suddenly means there's no scope or that the application is at risk for some sort of jurisdictional point. So sorry to interrupt, but I just did want to address that.
Thank you.
So that was clear.
Thank you. And that potentially answers my question, which is there's also planning evidence by Ms. Clouston, which discusses the potential for new privacy effects. She raised concerns that there was a different design element, balconies overlooking properties, and so she had a concern that that would introduce new effects, and therefore that was potentially a scope issue. Do you have comments on that specific matter as well as the other potential rule breach?
Yes, look, I think that is principally a matter, firstly, for evidence to understand, is that a material issue? And if it is there a way to mitigate that? And if there isn't, then you will need to determine, is that change therefore introducing an additional or an increased effect? And therefore, does it legitimately raise a scope issue? And I guess I would say there needs to be some flexibility rather than rigidity in determining the scope issue. And I think the authorities use the phrase that it doesn't in substance become a different application. And so I would say, well, look, all of the bones are the same. We're not suddenly turning 6 units into 8 or 6 into 7, or introducing duplexes, or that suddenly and very obviously becomes a substantively different application. Here, there's been a little bit of reshuffling, and possibly some should we say different effects or slightly differing effects, both potentially positive, and certainly that's the reason that the applicant has agreed to make them, because that they want this to be a better outcome. And if there are some very marginal different or increased adverse effects, I would say if you're still satisfied that they're minor or less than minor or acceptable, because those thresholds, I won't say they're meaningless now, but they're obviously most important for notification. And really your task now is to understand what those effects are, and are they acceptable in this context?
Thank you, that's very helpful. One further question from me. Mr. Dunn, in his supplementary evidence, raises a statement about land covenants being a private instrument. And I wondered from a legal perspective whether you had any comment on that for us insofar as that relates to the matters before us.
Yes. So look, and I will let those in the room confirm if they need be, because that is a matter, if you like, for the applicant in terms of what are they prepared to offer up. As I understand it, in terms of that limited infrastructure issue, they are prepared to offer up a covenant. And I apologise, I can't remember if it is addressed in the consent as an OGIA, as a consent conditions, effectively as an OGIA condition. But if it isn't, and again subject to advice from somebody in the room who's sitting next to the client, if it's not in the conditions, we are happy to propose some wording with the reply.
I'll make a bit of clarification, please.
Yes, sir.
I think the question, James, was about the private covenant, not the potential covenant we are offering up with regard to the low pressure sewer system. So it's to do with the private covenant on the adjacent land and whether it impacts and how that private covenant, which is not an RMA covenant, how that impacts all the client's proposed development.
Right. I'm not across that detail, so it may be something I need to come back to. So if it's that covenant that is the question, I would generally say private covenants are not an RMA matter. Obviously, unless they're offered up to address some sort of effect, and any impact of a covenant and whether it restricts the implementation of a consent is something that really is at the applicant's risk or the consent holder's risk. But as I say, I'm not fully on top of the detail of that covenant, so if perhaps I can address that in reply.
Thank you. I've got one further question. Just, Mr. Governor Hopkins, just on the wastewater servicing for units 3 and 4.
Yes.
I think I understand all the evidence on that, and that there's a condition being offered that the council's team will treat it either one way or the other, low pressure or gravity fed, and that one of those solutions is potentially better than the other in terms of potential effects on the waterways and the like. But I'm just not sure why this hasn't been resolved, to the point where it's been nailed down. And we have got the council's engineer coming in tomorrow and asking some questions. But does your team have an engineer, a consultant engineer who's looked into this, or is it just Mr. Dunn's been talking to council? But why can it not be resolved with certainty at this point?
Yes, and look, I think the applicant has taken some engineering advice, and others in the room may be able to tell you more about that. But I think the fundamental issue is we see that as a matter of detailed design, and certainly capable of resolution at detailed design. And in some respects, we'd like to have the certainty of consent before we go to that cost of, designing a solution.
Right. No, I understand that often is the case with consent applications, but there must be a fundamental problem, with those two units, which I'm fully aware of. That means further assessments required. But what you're saying to us is don't worry, it'll be covered by, there's a solution available, I think is the key point. So,
correct, and as I understand it, a solution available that the council can, yes, for want of a better word, can live with. So if it's a pumped solution, it's not ideal, but it is acceptable. As I understand it, that's the position we've got to. But the council effectively doesn't want to give the applicant, if you like, a free pass and say, okay, just go with your pump solution. They want really the applicant at the detailed design stage to demonstrate that a gravity system can't work, and only if that is the case will the council at engineering approval stage accept a pumped solution. So that's, as I understand it, is where the balance has been struck. And so inbuilt into the conditions is a preference for do your design work and demonstrate, if you like, beyond a doubt that those two units can't be served by a gravity system. And if you do that, then we'll look at approving a pump solution.
And I assume that the design work is quite detailed, because I'm just looking at all the information we've got in front of us now, the in-depth urban assessments and all the other, traffic, every other thing's covered, but not this. Are you telling us that it's quite an expensive, complex exercise to do that, or what is that the key problem?
Well, I think it's partly yes, and partly because we have got to the point where we've got an agreed, if you like, optional approach with the council's engineering team. If we hadn't, and if we hadn't reached that position, then we may well have had to go out and get that engineering work done. But as I say, I think you can be comforted by the fact that we have got the council over the line, and that the preferred system will be adopted unless we can convince them otherwise at an engineering approval stage.
All right, understood. So thank you. We did ask you a number of questions. Apologise for that, but we can now move to your first witness. So thank you.
Fantastic, thank you. And we were intending to call Mr. Bruce Weir first up.
That's fine. Just give us a few moments to
Yes.
bring up statements, and also. Going to check if we have some hard copies, but we can get underway with what we've got. But it's fine.
And look, with your leave, I might just turn my screen off if I'm not talking.
Yes, that's fine. Absolutely.
Okay. Thank you.
That's fine. Thank you for that.
So we could put it on a big screen.
Yeah,
Screen.
all right. What we'll do is we'll just, Mr. we'll just go to your evidence in chief, and well, you've got evidence in chief and you've got supplementary evidence, and to some degree the supplementary evidence is probably more relevant, isn't it? Because the plans have changed, but we have, I think I've got some questions at least of your original evidence, but so we might do that sequentially. So,
Sure.
So maybe if we go to your evidence in chief, and then we'll see if we have any questions of that, or if you want to highlight anything first, it's up to you.
Perhaps I just sort of generally set the tone.
Yep, absolutely.
Right, open to that. And I think broadly there's quite a level of alignment between myself and Macedon on behalf of council in terms of the appropriateness of the site for development. The difference is the application of how you execute development on the site fundamentally. And it comes down to the interpretation of the context. And I guess that's sort of, where I've come at it in my assessment of it is that the Master Lake Reserve is actually really quite an urban environment. It's got a high level of impervious surfaces, apartment style development, albeit dressed as townhouses and road sheds. And you've got certain contextual clues about how you would approach the development on the site. Area in place being, so sort of, I don't disagree with Rachel in terms of that area in place is more suburban character, because but it leans quite heavily on the fact that there's a sense of openness that's created by this massive at-grade parking for the, so it's sort of borrowing all of this amenity. And it's actually, to be honest, it's actually quite a kind of, for a simple area, it ends up quite complex in terms of what the character is here, because quite a lot of buildings present quite an urban front to the streets in the public realm, and they open to the promenade, the boulevard, the lakefront on the other side, which is what you'd expect them to do. And so it gets quite complex, and it was really around, I think the points of difference that the two of us had was really that I see the lane, the one-way lane, the internal lane, the shared lane as a better solution than having lots of driveways, which would be the alternate, is to flip it back to front, is a better urban solution that's appropriate in this instance. So that's sort of the broad context.
Actually, we might ask you questions as you go, if that's okay.
Go for it.
And yeah, so just to confirm a couple of things that I think I've got my head around the plan, the zoning. My first impression was that the different zones with the Marsden Resort, Lake Marsden Resort, and the residential area that surrounds this site are different zones, but they're not, are they? They're the same zone, and they're precinct 1, RR3, RRA3, precinct 1. So the first observation is that they're quite different characteristics, aren't they? Those two, and is that the basis for your
Correct.
Your theme, if you like, that this is a transitional area between the two? Yeah,
it is. It's and look, it's just sort of like, I think the original developers that look back on it and they might do things slightly differently now, the actual resort, but the actual intent of that you have a sort of a larger lot buffer around an integrated development is, what I probably would do in principle anyway. And the fact that these two lots are sort of sat there at the end of this development seems it's sort of anomalous. You're sort of what were they thinking, leaving this out? It's a natural extension of a more intensive environment. But yes, it's the same zone.
I think you've stated this in your evidence somewhere, that what is the relative density between this proposal with 6 units on this site and the Lake Marsden Resort, the ones that Chuck out?
Yes,
Have you done that calculation?
I started doing it. My pretty coloured diagram, but then I just realised I included Rahoy Close in there, which is actually a public road. So the density, it's so hard because some of the parking is actually required for the Pisa Moorings Cafe and Bar. And so what do you take as the development? It's a very similar density is my answer. I did do it, and when you actually take the 2 lanes, what I assume is the parking area. So even the density gets confusing too in Pisa Moorings as well, because they say that they're 2 units, but some of them are 3, and they're, unless you physically go and count.
So if the densities are similar, accepting it's hard to calculate, if they're similar, how does it form a transition? Is that through the design or the density?
It's much more of a design response. So you've got freestanding freehold houses on the roads around it. Buffer to the highway, larger lots, you'd expect that. The bigger lots to the north that overlook the estuary on the opposite side, the northern side of Foster Place, present quite an urban frontage to the south and then open to the north. This is, it's not as, you could have done this site as in a similar style to the Marsden Lake Resort apartment style, maybe some at-grade parking was one option. I hand tested a number of configurations on site as how I do it, and I call it transition because it's more townhouse. So it's more compact, it's freestanding, it's not a big house on a big lot. That's hence why I call it transition at that point.
Right, understood that.
Yeah.
Thank you. When we were on the site visit yesterday, standing on the site and looking through the inlet and onto the other side of the area, it's visually lower density again.
Yeah.
And obviously it's the same zoning as well. So my question is for you in terms of your opinion and advice to us that it's a transition. If it returns to a lower density on the other side of the inlet, would it be fair to say that the higher density relates to a pocket around the inlet as opposed to transitioning into a higher density area?
Yes, correct. It's a pocket around. Yeah,
So it's pocketed around the wee inlet there. And
correct.
so can that site act as a transition then? If it's not transitioning to a higher density area,
Yeah,
it's transitioning to a higher density pocket. That's my question.
this is the problem with the vacant sites to the north, I guess, is sort of second guessing. I guess, and this is where the broader context comes into place, where you've got, another 290 dwellings coming up at Pazensky and Mackay Land north. Then we've got the Parkburn, even more substantial to the north. And so I look at the vacant land between Foster Place and which is all under one contiguous ownership, and I go, oh, it's a very expensive land, and will it stay large lot, or is it, financially it's actually worth looking at non-compliant applications and other options, and you just be patient, So, that's from my, I guess, developer side. Knowing clients that would look at that, one big parcel is pretty attractive in that location. But in terms of this immediate application, I think the having freestanding dwellings on this site in the form is a transition from what's essentially apartment development on the waterfront through to a surrounding residential environment.
Thank you.
We've started asking you questions. Did you want?
It's okay. No.
Do you want to carry on with any other points? Or we'll carry on.
Yeah, that's right.
We're still dealing with probably the wider, the original proposal. So not the detail of it, but the fact that you're building on the site of 6 units. So we're sort of at that level at this stage, and we'll go into amended plans at some stage. But just in terms of the breaches of standards, there are quite a few. If I've got it right, they're over height by just less than half a metre. There's recession plane breaches, and I've got to get this right. I know there's recession plane breaches on the eastern side, but possibly on the southern side as well. Mr. Dunn might go and confirm that. Is that still the case or not? Under the operative plan.
I'll need a double check, Mike, but that's what it says. Because
Okay. What I read this morning was that there's recession plane breaches on the southern side and the eastern side. There's the 15 metre yard requirement. Other yards on the south side, I think, that they're still right to the boundary. The height, it's over height as well. So when I see those sorts of breaches, I often ask the question, why can you not comply, or at least comply more fully, shall we say, and still achieve the design outcomes that obviously you've tried to achieve a really good design outcome for the client, but are they too inhibiting? What are the principal reasons? Does it just come down to the effects assessment? There's no difference from a compliant club. Is that the position?
So I defer to the modelling that was prepared by the architects, the Space Lab, where they showed the consenting building envelope, which is blue.
Yeah.
And I would take it there.
These ones,
yeah, correct.
Okay.
And the breaches, in my opinion, are sort of they protrude through in certain areas at certain points, but they're not substantive in terms of the effects of shading and any additional effects. And they tend to be contained either within the road itself or which is, look, there are, it's cold down here and you do get icing at certain times of year. But when you've got the deep shadows, it's going to happen anyway. So minimal additional effect of those. And I guess the ones that the neighbour would have issues with are the ones into the car park or onto the footpath south of the site, which, one's impacting vehicle access, and the other one with the walkway on the eastern side. I think the benefit of, taking away some sort of architectural details, changing roof forms, like it could be looked at to minimise it. I'm not sure it would.
So just to help, I think I understand this, and I want to make sure I do. So the blue diagrams appear to show just gable intrusions, like gable type intrusions on the roof of the recession sunlight shading recession planes. But isn't the whole chunk of the building right on the boundary, which means there's also a setback intruding not shown on that as well?
The setback should be included. It's on the 15 metres, sorry. Yeah.
Oh, no, you won't be able to show that. No. Just trying to understand that these diagrams are presented to show that the bits that aren't blue are the only bits that don't comply.
Correct.
Is that from a shading point of view?
Correct.
Okay. Okay. And then I understand that they appear minor compared to the rest of the building, but in terms of the shading diagrams that are presented, and there's been some discussion in the evidence we've received that they don't show a permitted baseline scenario, so we don't know what we're comparing against.
Which bits are actually
and so
additional.
So I guess the question is, why didn't you do that? And if you didn't, can you make some observations about it might help us with what the difference would be? Yes.
Yeah. I'll talk you through them. Look, my apologies. It's just a matter of getting plans done in time for the for the hearing. But I guess the key ones to focus are on the eastern boundary. And if we look at middle of winter, June 22nd is a good example. You'll see that, in fact, always at 3 p.m, 12 p.m, the buildings themselves, almost irrespective of height, are shading down towards as you'd expect, down to the southeast, which is where the walkway comes through. And you can sort of see the gable end of the building is actually out towards the water. So while if you took that gable end off of unit, that would be unit 4, it would bring it back in, but it would still impact the walkway at that point.
Yeah, so these shading diagrams appear to show no shading impact on the closest unit, number 12, at the resort. Is that
That's right?
In all of these scenarios, there's no shade that falls on.
No.
Is that right? Okay. And then the other question I had was, recession planes are not just about shading; they're also about visual mass or outlook, or potentially views of the ranges. But I'll have to ask Mr. White what the intention of this plan is of recession planes, whether it's to protect views. It's not normally the case for district plans, but some of the submitters have complained, and I guess their point would be that if you fully complied, they might have a better outlook, or at least less massing near their boundary, putting shading aside. Any thoughts on that?
It's this is the one with, what would happen if you did 2 big houses, 2 large houses, and how would you build them on site? Would you build them single level? Would you go up to 2 level? How close to the street would you build it? It's an expensive environment now, and I personally would be going for views, and I'm allowed to go up 2 levels, so I would be pushing garaging to my southern boundary, and I would be seeking height.
So with two dwellings, if this was just built for 2 large dwellings, would they have to be quite large to sort of provide the same amount of, how do these 6 smaller footprint units compare with? They'd have to be particularly big with it to do the same thing.
Yeah, I guess they would be pretty big, because you would try and do a minor residential unit as part of it.
Okay.
I mean, this is one of the problems we have. Of course, we're not talking about affordable housing. It's not an affordable area. And the big houses, and they command good money, and they are close to the water's edge, and they've got good amenities. So you do a minor residential unit, you'd make it a bigger house, you'd have independent access.
Yeah, I guess just trying to explore how realistic it would be to have two large dwellings that would have the same effect on neighbours in terms of outlook and massing. And I mean, we can't speculate, but I guess they'd have to be quite large to provide that sort of thing.
I don't know if they'd have to be that large, to be honest. I think they would, to some degree, I think there's actually quite a decent amount of permeability through the site. Because everything, of course, depends where you take view from and which angle you're looking at. And if you're looking absolutely at perpendicular, and the moment you go 2 levels, somebody's always affected behind. It's just in some angle. And as trees grow on the street and all those good things, it is one of in the area I live in, we've got exactly the same issue. People on one side of the street who thought they had views of the water have lost them because the trees have grown in front, and but you understand that when you buy a section back, that things are going to occur there over time and things are going to grow.
And one other question, so I'm asking you questions, but the height breach, which is about 0.4 of a metre, I think, is that caused by the actual ridge line?
Correct.
That's not the little bits that stick, that's the actual ridge of the building.
Ridge line, yeah. So the options there, yet again, is you could, slightly reduce the ceiling height inside the dwellings. That has, and you have to balance the impact of that minor breach, which is in my opinion, a technical breach of the roof, as to the livability within the dwellings themselves.
What's the technical breach?
Well, just the fact that you've got a pitched roof, I would be horrified to do skillion roofs for it.
So it's the top apex of the triangle, the ridge line.
The ridge line.
Okay, look, I've asked a lot of questions on that design. And turning to the amended plans, we've studied the changes that have been made, and just probably keen to explore the differences again with Ms. Eaton. And did you want to talk us through anything there that
Absolutely. Well, it's the major difference, and it's this good old thing of fronts and backs, and I guess it's these houses feature what I would consider sort of courtyard living, which is optimised to the north, and it looked at the option of bringing, and so by default, when you have that style of living, you expect to have landscape buffers, you'll have permeable fencing, but you have elements of strong walls to create privacy. Now, if we did the entryways, and I would expect that there will be footpaths and entryways for the dwellings, it's where you bring your bikes and those sorts of things off the street. But for the casual user of identifying where the front door is, which is, I think, the major intent, is that we explored a number of options of shifting pathways around. And at the end of the day, I came back to the fact that I think it's better to concentrate that pedestrian activity to the internal lane. It's legible, you understand it, vehicles are travelling in one direction. This, the benefit to the street of having optimising visitor parking, all those good things of the lane, and the courtyard living, that this is better than having a whole series of different entryways, pedestrian entryways in this instance, for the visitor.
So the residential houses surrounding have got that. They've got the traditional sort of entrances. The resort is something different as well.
That's right.
And back onto this area, don't they? And all the servicings at the back.
That's right.
And you're proposing as a sort of a single
lane through.
Lane through. Yeah.
That's right. And so, and that's where it's sort of it is different. Pisa Moorings has the lane, and like you said, it's got the footpath within it, and it's massive. And I don't know how many people actually use the footpath actually out on the street, but I suspect very few walking down that way. On Imperium Place, yeah, look, it's they're actually all quite different environments, and that's the challenge that I guess we've all had with this particular site.
Did you have any involvement with PC19 at all?
Not with this site.
No.
I did elsewhere, but not this one.
But I think the both commissioners were quite interested in how the zoning those lot residential is the appropriate zone for the resort. Within what it is. Well, at least not questioning that so much as the divergence between that and the surrounding residential area are in the same zone.
Yes.
It just seemed strange.
I wish I'd known the applicants before. Before that all went through and we could have put in the submission, because I totally agree. I just I guess that's what we're all grappling with. We can see the wider context of all this. It's essentially a new. It's a new sort of village, a new small town in its own right. That area to the north. And then there's this sort of clinging on to almost a quasi-rural ambience. And like, I accept that, and people are scared of change. But you can see those pressures that over time this is going to evolve. It's the little there's Pisa Moorings Cafe and Wine Bar. They kind of exhibit some of the things you'd expect to see. The living's out to the street. The gateway comes through. There's different entries, laneways. All of that's sort of going to start coming into this area over time. This is just a little ahead of its time, I guess, in some ways. Another explanation for transition.
When you say evolve over time, the PC19 direction doesn't suggest that this area will change over time. So what are you basing?
Look, I think there's that's just those wider factors of growth. And everything evolves over time, nothing's static. At the moment, those large lots down against the state highway make perfect sense, absolutely perfect sense. Big lots, motorway noise, Elf Road, highway noise, you want to retain that. It's kind of, the pressures all around the district where, big expensive houses, there's a point where a number of those get put under pressure just by virtue of the fact that you have such good amenity, being water frontage, and this is a change that we see everywhere.
In terms of this application and this proposal, though, you'll acknowledge that we have a zoning.
Well, that's right.
Which sets out a direction for what is envisaged in this account.
I think it's and this is the difference, I guess, Mr. Gardner-Hopkins outlined, is that the zone for which, when it was, I guess, sought, there was an acknowledgement within the residential chapter that a more intensive or a more intensive form of residential in the Pisa Moorings area was anticipated or appropriate. And I guess that's how things evolved at that point in time.
I just think we understand the discussion around the balance. I'm going to call it the balance site, the piece of the piece next door to the site, and the screening and read like evidence on that. And there's a suggestion that there could be a condition to probably for done that at some stage in the future there might be a need for a 50% permeable fence built there. But that little piece of land is part of the wider resort, isn't it? It's sort of
held in common.
Quite sure what would happen with that site, but if it's built on, your evidence is focused on not providing a screen so much as providing for sort of a transition area, if you like, the outdoor living areas and the like. And yeah, so that you are willing to accept that condition by the sound of it, it's been volunteered, something in the future.
Yeah, look, it's, yeah, that's right. That's right. The clarification, yeah. If it was to be built on, I then put a fence up, but I would say that at this point in time, I'd try and resist putting a fence up unless it was for keeping animals in or something like that. I think it would downgrade the value for everybody.
No, that's fine. I've got questions.
In your supplementary evidence, or perhaps your primary evidence,
Yeah, that's okay.
You've got graphic attachment B, Perium Place Streetscape Villages.
Yeah.
It would be helpful if you were able to just speak to those in terms of what it is you are illustrating through the inclusion of those images.
Yeah, sure thing. So the what I was trying to draw attention to with the two images from Perium Place were the fact that when you go and look, it's actually the sense of space and openness is actually almost fully contained within the road itself, in the streetscape environment. And a lot of houses either are largely car parking at the front or have garages to the front, as you'd expect, and the front doors are set well back. That's on the properties on the western side, obviously. When you get the situation with the same outlook and aspect, now I'll try and recall my numbers, but for example, south of, which was one of the images I put on the second image, was south of the cafe and wine bar.
Yes.
Where that's got the living to the northwest on the property, and they've actually bunded up, the property owners have bunded around that edge and created a wall to shelter and create that privacy, because the living's not to the rear of the site, it's actually out to the street. So you've got sort of the wine bar itself where it has the court out onto the street. You then have the properties below that actually have created walls because of creating privacy. So the conditions are different on one side of the street to the other. So I was really just saying, look, there's not I want to draw attention that I don't consider it a massive problem having the living spaces out and towards the public realm.
Thank you.
I did ask Mr. Gardner Hopkins about fine grain detail of the urban design assessment, and that's one of the things I had in mind was the concern about people having outdoor living spaces near the street. Is that something that the restricted discretionary assessment criteria? So they certainly don't mention that, but if Mr. Gardner Hopkins accepted that they would include streetscape and other things, but is that something you think is important? Design perspective.
Yeah, look, I know that Ms. Eden said she would prefer for the living to be to the rear and the front doors to be really obvious from the street, and that was really where the difference between the two of us are. If you look at Foster Place to the north and if you get back out on site, it actually has a lot of driveway crossings. It's relatively urban because it's borrowing. It's sort of its pedestrian front door is the waterfront walkway and boulevard, or not boulevard, promenade, and so it does a different thing.
Yeah.
When you're going down Perium Place, they need the amenity behind. They need the big lots because it's dominated yet again by parking and driveways, and then so there's sort of different conditions, and this site is doing something which is it's different. It's a bit more intense than the development to the south of the cafe and wine bar, but it's similar, the same sort of conditions.
Right, understood. No, thank you very much for that. We'll come back when we finish with you now. But we'll talk to Ms. Eaton tomorrow, and it might be, I'm not sure if you'll be here tomorrow, but I appreciate if there's any response, if there can be any further alignment of views on that. But,
Yeah.
Thank you very much. Now, thank you. No further questions. I know we've got Mr. Bartlett here, and we haven't got many questions for you, sir. So what we might do is take you now and then have a short break for tea, and then come back to Mr. Dunn before we finish. Okay, thank you. So yeah, come forward. Thank you. I'll just get your statements up.
I'll come down. Yes.
Yeah. Okay. So,
If I may, what I'd like to do is just briefly run through my summary of evidence. There's a couple of wee minor corrections in there that I'd like to take you through and fill into the.
So we haven't actually read that yet, so because we've only got it today, but we'll. We've actually got it here. Summary.
No, not summary. Sorry, supplement. Oh, sorry,
You've got that.
my mistake.
No, you do that. It's that's appropriate. So please do that. Yep.
So thank you. My name is Jason Bartlett, and I'm a transport engineer. If I may just quickly run you through my statement of evidence. And there's a couple of minor corrections there that I'd just like to make. It was essentially based on an interim design. So if I could take you to maybe paragraph 16. In that paragraph, I talk about that each unit will have a single garage car park space, and the design is being altered. And just to confirm now that each dwelling will have 2 car park spaces, and that is a single garage car park space and a second driveway space.
Right.
So that correction also follows through to paragraph 19. Which is essentially the same thing. And I suppose as I'm here, I'd just like to draw your attention to my involvement with other projects in the area, in the local environment, where I assessed parking within Perium Place for a development not far from the site, and suggest that any possible parking can be accommodated within the existing road environment. And also at paragraph B, also with my experience with Plan Change 19, as we were discussing before, particularly with the Polinsky and McKay extension of the Pisa mooring zone, which was about approximately 290 odd residential dwellings. That was modelled through the intersections that this development would also use to get to the state highway. And so based on that modelling, the local road network has sufficient capacity to accommodate any increased traffic as a result of the proposed development.
Just on that, I don't know about that particular development, 292. Is that being consented and it's going to proceed, or is that?
It was Plan Change 19, so it was just to extend that zoning. I'm not too sure what the exact outcome was. I suspect it was something in the lines that it was a future development area waiting on sewage and or water. I'm sort of looking at the 2 planners in the room, but I have a picture idea.
But there's also been park burning, which
Yes.
we were sitting on, and we've basically granted a fairly large development there, and the capacity, the intersection of the highway would require upgrading at certain thresholds and trigger points throughout that. But you've considered that as well?
Yeah, I have considered that with Plan Change 19, essentially for within the Plan Change 19, because Parkburn wasn't part of that because it was separate.
Because a separate plan.
I hadn't increased the traffic flow on the main state highway because of the processes of development where it was at.
What you're essentially telling us is that we need to worry about this site having 6 units on it, because the network can handle 292, and you just said that Parkburn would be included in that. But are you saying that this is minor in comparison to that, or have you assessed the impact of this development on top of those things? It's included.
No, I haven't. So what I've assessed is the 292 only
Yeah.
as part of Plan Change 19.
Right.
And therefore knowing that the network can take 292 with acceptable levels of service, you add another 6.
Yeah.
But it won't be noticeable.
But you haven't actually said that in the evidence.
No,
but I understand what you're saying. Yeah. Thank you.
Yeah, no, basically, it's so small in
It's so
comparison
small,
to what I've already thrown at those intersections.
Yeah, we thought that would be the case, but it wasn't. So that's fine. Very good. No, that's fine.
Definitely. So, if I carry on there to paragraph 28, I suppose that paragraph couldn't be essentially removed. It talked about the car parks in the interim design. We're taken away, so it's
we probably don't need to amend your evidence because you've got a supplementary statement which
Exactly.
deals with
Exactly.
plan. So we need to make those changes.
Yeah.
They can stand on its own.
Yeah, exactly. And then I suppose I'm just going to take you to my discussion around the consent conditions.
Yeah.
At my paragraph 30C, I talk about the heavy duty vehicle crossing for the entry and exit into the laneway. I believe that's now conditions 15 and 16 under the current set of consent conditions that were part of Mr. Dunn's evidence.
Right. Okay. Yeah, that's fine.
And then like a similar sort of thing at part D, where I talk about condition 18 becomes condition 17.
Okay.
Same thing.
That's fine.
Yep.
That's fine.
And it now has 4.2 metre
That's
sealed width, basically formed width.
right. So
Across
no motion about that, but So is there anything you want to say about this supplementary evidence?
Supplementary evidence does not change. I suppose, if anything, I suppose just to reiterate my summary, really, that the transport design has been updated and refined. Each residential dwelling will have 2 car park spaces accessed from the one-way shared on-site access road, or lane, I suppose you could call it. I consider that this refined transport design is appropriate and suitable to serve the proposed dwelling, and I confirm that I consider the proposed development will not have any adverse transport impacts on site or within the surrounding transport network. And I suppose, if anything, probably sheet 2 of the plan set provides the best overview of the transport layout. It shows the swept paths and the parking and that sort of thing.
That's right. Thank you for that. Those two. All right, no, look, that's fine. I'll just to confirm the access or carriage road width was 3.5 original proposal. Now it's proposed to be 4.2, and that's what the council officers have asked for. And so, can I summarise it by saying that all the traffic aspects comply fully with the plan standards, or is there still some? You've got parking complies, the width of the access, the width of.
I suppose it's a little bit strange when it comes to the plan standards because they're based on 2-way roads. And we're one main road. So what we've got is a 4.2 metre formed width, and that's primarily based around those swept paths as those vehicles turn into the driveways. It's basically the width required to allow that vehicle to turn in and park on the driveway, or continue on into the garage. So that's where that 4.2 has come from. And I suppose in my statement of evidence, I looked at a couple of different standards and discussed how you could adopt those standards as a one-way situation. But in reality, as the refined design came through, we've settled on a functional approach to that formed width, I suppose.
Okay, thanks for that. And we have the council engineer coming tomorrow, but we understand that you've met his recommendations or concerns, but we'll ask them that tomorrow. So just finally, one of the submitters, and I don't recall the name, one of the submitters was concerned about traffic congestion. And any comment on that? I mean, what I'm taking from your evidence is that the traffic volumes are quite low on the network, and you've got a dedicated sort of one-way lane through. Have you got any response to that concern about congestion?
I suppose, well, let's start at the site and work out really. On site, we've got, in a peak period, we'll have a total of about 6 vehicle movements, 1 per dwelling essentially in the peak period, probably in the morning. Generally, they will all be flowing out. So we think 6 is 1 every 10 minutes. You're not really going to notice it. It's not going to change the efficiency of the intersection with Perriam Place, and it's the intersection of Foster Place with Perriam Place. And then based on my traffic work that I do within Pisa Moorings, it's not going to affect the operation of the 2 intersections, whether you're coming out onto Pisa Moorings Road and then out onto the State Highway. You know, the queuing at those was pretty small considering how much traffic I was throwing at it anyway. So yeah, no, there will not be a noticeable traffic congestion as a result of 6 or essentially 4 additional dwellings.
Thank you very much for that. You know, we don't mind if you can be excused now if you wish, because we have got the count. It's up to you whether you want to stay, but we won't have any further questions, and we will have some council traffic engineer, but not a lot. So it's up to you.
Thank you very much for your time.
Thank you. We'll take a short break now. Getting through it quite well, actually. We'll just take a break for 15 minutes or 14 minutes. We'll come back at 11:45. Okay. All right, we'll resume the hearing. We managed to get a cup of coffee, so well done. Now we'll go to Mr. Dunn, planner for the applicant, and I'm going to hand over to my fellow commissioner to lead the questioning on this one. So thank you. Thank you, Mr. Dunn. We've got the statements and you've got a summary statement.
I do. I will read that.
Yes, just to do that first.
Thank you. My name is Alex Dunn. I provided a statement of evidence dated 17 September 2025 and a further supplementary statement of evidence dated 31 October 2025. This is a summary statement of evidence and addresses matters raised in minute 5. I reconfirm I have read the expert witness code of conduct as set out in the Environment Court's Practice Note 2023. Unfortunately, the applicant did not get a chance to see the expert evidence of submitters prior to us sending council our supplementary evidence. There are several matters that would have been addressed as part of our supplementary evidence if we were afforded the chance to view this evidence as directed by minute 5. Regardless, I will make my observations as part of the summary statement. The key areas of disagreement between myself and the planners for the submitters appear to be around effects associated with servicing of units 3 and 4, the overall activity status of the application, the difference in wording between the Section 95 and Section 104, shading effects and urban design effects, which Mr. Ware has already spoken to. With regard to servicing, Council have confirmed that the applicant can use a low-pressure sewer system for units 3 and 4 in the event that gravity connections cannot be made. The conditions of consent as recommended are typical for a development of this nature. It is standard for engineering acceptance conditions to require detailed design works to take place following the issue of consent. Utilising a low-pressure system is considered to be appropriate as they are relatively common. Servicing of wastewater is considered feasible. Likewise with stormwater, if on-site disposal is utilised, stormwater from all impervious areas will be stored for reuse or disposed of by a soak pit designed by a suitably qualified and experienced person. Council has also left the option open to connecting to the reticulated system, provided approval is obtained from the Council's Three Waters manager. The applicant accepts this condition. Once again, it is not uncommon for further approvals to be required from council departments as part of the engineering acceptance process. With regard to the overall activity status of the application, I am of the opinion that the application remains a restricted discretionary activity. When calculating net site area, the plan requires that access strips or right-of-ways not be included in the calculation. Access strip is defined as, and I've defined it in the first part as of relevance, which states in relation to a rear site or allotment means. Ms. Mackay has pointed out that as this definition includes a road allotment, then the access, as shown on the plans, is an access strip and cannot be included in the net site area calculation. My interpretation of the definition is that an access strip only applies to a rear site or rear allotment. Site and allotment have different definitions within the plan. The purpose of this definition, in my opinion, is to capture both a rear site and a rear allotment, not all allotments, such as front allotments. The wording is open to some interpretation, but the fact that there is no comma after rear site means that the two terms, site and allotment, are linked by the word rear. If this was meant to capture all sites and or allotments, there would be no need to mention the word rear, and the definition would simply be in relation to any site or allotment means. Turning to the 15-metre setback requirement, I acknowledge the plans show the setback from the actual lake margin as opposed to the property boundary. In my view, this is not an issue when it comes to an assessment. The assessment can be made from the property boundary, and this assessment can still be made even if the 15-metre setback as shown on the plans is from the actual lake margin as opposed to the boundary. For completeness, I note the following further assessment to address submitters' concerns. The existing environment is comprised of Marsden Resort, which contains units that are located over the lake margin and lake itself. Therefore, having built form on a site within the same vicinity of Marsden Resort will not be out of character. It is important to focus on the matters of discretion. It is assessed that due to the setback of the proposed buildings from neighbouring properties, amenity values relating to access to sunlight and maintenance of privacy will be less than minor. Further, no adverse noise effects are anticipated by the activity. The units of Marsden Resort essentially overlook the lake, and the development proposed by way of this consent will effectively sit in behind the established resort units. For established residential units located on the opposite side of Perium Place and to a lesser extent Foster Place, development of some form on the subject site is anticipated given the zoning. It is assessed that the lake margin setback breach in this instance will have a less than minor effect on the owners and occupiers of surrounding properties. Effects relating to amenity values on the neighbourhood and streetscape are minimised by the implementation of landscaping. I consider that there is a positive relationship between the units and the streetscape. While the main entry door will not face a street, common living areas with large external doors for units 1, 2, 3 and 6 do face the street. I consider this will have a more positive relationship with the street compared to having a main entrance door facing the street, with the common living areas and outdoor areas being moved. For units 1, 2 and 3, this would move the common living areas and outdoor living areas to the south of the building, which would restrict future residents' access to solar gain and limit opportunities for passive surveillance. And just in conclusion, the lake margin setback breach won't have any adverse effects on the wider roading network and infrastructure. I consider the lake margin setback breach will result in less than minor adverse effects on the wider environment and on any persons. I disagree that there is an expectation that neighbours can reasonably anticipate the area will remain free of built form, especially when the existing environment, which is comprised of Marsden Resort, is taken into consideration, along with the restricted discretionary activity status of the consent. It is clear from the plans provided that there is good separation between the units and the actual lake itself. While it is accepted more built form will be within the 15-metre setback as measured from the property boundary, the proposal does not introduce a new or unexpected built form outcome when compared to the existing environment. And once again, I'm just making the point of Marsden Resort. Part of the existing environment, the units are over the lake margin and lake itself. Ms. Houston has raised concerns with regard to the different wording of the Section 95 and Section 104 assessment. I note that at the time the Section 95 was completed, neither the council nor the applicant had engaged in urban designer, and just making the point that Section 95 is to determine who is affected, and Section 104 does provide a pathway for consent to be granted, even if effects are assessed to be minor. And just to confirm, as part of the original AEE, there was a statement saying affected person approvals had been received. That statement was not correct. Just turning to shading effects, the shading effects will be minimal at most. The June 22 3 p.m. shading diagram shows some shading extending over the footpath area. The extent of shading is extremely minor and not uncommon for that time of year, considering the low angle of the sun in the sky. During other times on the day of June 22, most of the footpath will not be shaded. This means that any overnight ice formed will have a good opportunity to thaw before being shaded again at 3 p.m. Of course, there will be exceptions to this. As we know, the inversion layer around here can last for several days with temperatures not rising above zero. But during such events, ice can form in most exposed outdoor places, including places not shaded by any built form. I therefore consider that shading effects will be less than minor, including on the footpath. I welcome any questions from the commissioners. Thank you.
Thank you. 1.6 of the summary statement. You've talked about your opinion around the application and the restricted discretionary activity. What is your understanding of what turns on that if we were to find it to be a fully discretionary activity?
Can you repeat that? Sorry.
What turns on that? How is that relevant to our decision if we found that it did require a fully discretionary activity? What does that mean?
Yeah, I guess, fully discretionary, you could consider anything. So we would have to open up to more than just the matters of discretion to look at. But I think, as Mr. Gardner-Hopkins has alluded to, the matters of discretion are already quite broad in a general sense. They make general reference to amenity, to infrastructure, to transport. So I would say it wouldn't actually change much about the matters you would look at assessing. And I think Mr. Greason made the point in his legal submissions. It does become a bit of a moot point, which I would agree with. Yes.
Thank you. In paragraph 1.9 of your summary, in subsection A, you've stated the existing environment is comprised of Marsden Resort, which contains units that are located over the lake margin and the lake itself. Therefore, having built form on a site within the same vicinity of Marsden Resort will not be out of character. In terms of there's more in the existing environment than the Marsden Resort.
Correct.
So can you just talk me through, I mean, you've touched on this through the different iterations of your evidence.
Yeah.
Can you just explain how you have arrived at that overarching statement, please?
I think a lot of emphasis from the submitters has been put on compliance with this 15-metre setback and how it's been demonstrated on the plan. So, for example, we're showing it incorrectly at the moment from the actual lake margin as opposed to the property boundary. So looking at the existing environment in terms of the portion of land essentially bordered by Perry Place and is it Forster Avenue, just that portion of Foster Place, sorry. So essentially looking at the portion of land between Perry Place and Foster Place, looking at this land in here sort of as its own sort of area, acknowledging that, these allotments adjacent to the highway and whatnot also form part of the existing environment. But when I've been looking at the effects on the lake margin itself, the Marsden Resort forms a good baseline to assess it against, because I guess these dwellings that are set back and on the opposite side of the streets are not within close vicinity of the lake.
Okay, thank you. And you've highlighted that we don't have a correct plan in front of us showing a 15-metre setback.
Yes.
Is that helpful for us to see, in your opinion? Why do we not have a correct plan in front of us?
Yeah, no, that's a very, very fair question. These plans took a bit longer than we would have liked to get produced, and unfortunately the incorrect setback was put on. As part of our right of reply, we can show that 15-metre setback. Yes.
Thank you. I know some this submitters that are represented by a planner, they've created their own image.
That they have, and I think in the context of assessing the application, you can still see where the units are in relation to the property boundary and in turn in relation to the lake.
Yes, and that having a correct map would visually depict the identical built form within that 15-metre setback. Yeah.
Yes.
Thank you. At paragraph 1.12 of your summary, you've said it is accepted more built form will be within the 15-metre setback, and we'll be able to see that clearly when we have a correct plan.
Correct, yes.
As measured from the property boundary. The proposal does not introduce a new or unexpected built form outcome. On what basis, and speaking from the planning framework, so not urban design or design response, but from the planning framework and the zones in front of us, how have you arrived at the statement that the proposal does not introduce a new or unexpected built form outcome?
There was a general sort of statement. I'm not talking here about the number of units. I'm talking about development on the site as such. So both
Development of all.
like overall development, yes. So I guess what I'm saying here is, look, we've got 2 sites. Each site anticipates a residential unit, and there's a right to have a minor residential unit associated with their primary residential unit. So looking, stepping back and looking at the wider residential context and the context of the area from where submitters are on the opposite side of the street and whatnot, when they look toward the site, it is expected that there will be some built form on the site. And exactly where that built form on the site, is open to interpretation. Yes, we've applied to breach the lake setback in this instance, but likewise, if that 15-metre setback was complied with, it would actually push, potentially push built form right closer to the street and actually closer to submitter's property. And as Mr. Weir alluded to, it's really hard to say what a permitted development could potentially look like on this site. So yeah, I guess my point is more built form is anticipated in some form on the site.
Okay, so that's different from what you've written in terms of unexpected built form outcome, or when we look at the built form outcome for this specific proposal, it is 6 units. And so how I read that is that you're saying that that's not unexpected.
Okay.
So is that not an accurate phrase?
Yes, probably should have written it there, better, sorry. Yes.
Thank you.
Yeah.
Thank you, that clarifies it. Thank you. You've answered some of my questions already in your summary. In terms of your primary evidence, at paragraph 6.2, you have raised the nature, you've raised the appeal, plan change 19. Can you talk me through your understanding of the nature of that appeal and how that might impact our consideration of the proposal in front of us?
I would have to address that in the right of reply so I get my specifics correct. But in general, my understanding is if it is a site-specific appeal, then the PD or the plan change 19 rules would take precedence over the ODP rules. And I think this is where the conflict is, because we have a frozen activity status. So then it comes, well, how do we apply, if the new rule does apply, and if they do apply, how do we apply those rules with a frozen activity status? So yeah, I would have to go through the specifics of that appeal to answer that.
So when you say site-specific, my understanding from reading the document, the material that we have, is that it relates to a piece of land north of Cromwell. However, the relief sought relates to the provisions of.
That's my understanding too.
So in that sense, how can that be site?
It's not, is my initial thinking, but I just want to confirm that before I provide an answer. Yes, I agree with you. The appeal does relate to a certain piece of land, and if that appeal is successful, it will have, it will change essentially the provisions for every site within the same zone.
Yeah, so it would be good for us to see, and if you're going to address that, the possible outcomes or resolution of that appeal and what that would mean for the relevant planning provisions. Thank you.
Yeah, just on that, Mr. White, it would be good maybe for you to give us some update tomorrow and present any information that's available as to what the process is for resolving that appeal. Is it in limbo? Is it being actively progressed? Just to give us some feel for where that's at, it would be useful if you could find that information.
Yes, I'll need to make inquiries.
Absolutely. You don't need to pick an answer right now, but it would be useful just to know where it is in the system, because comfortable waiting.
in your primary evidence, in reliance on the urban design input, you do refer to the transitional interface.
Mhm.
And I am interested from a planning perspective. In terms of the zoning we have in front of us, there's no interface zoning, and we've got a very recent plan change 19, which zones the area as low as LLRZ. So from the kind of front-of-your planning perspective and analysis in terms of the framework that we have, how can you justify calling that a transitional interface?
I guess, transitional interface, when you're relying on urban design assessments and other experts, there are a lot of terms that are not strictly defined by the district plan. So this is one of those terms not strictly defined by the district plan. I think Mr. Weir alluded to it before. Considering Marsden Resort is there, it does seem somewhat somewhat odd that large lot residential zoning would be put over that existing resort. If looking at it, not being involved in PC19 or PC19 in relation to this site, looking at this land here, you would almost, have different zoning over the entirety, down from the cafe, wine bar, Marsden Resort, and the subject site itself. It is home to, more intense development style when you compare it to the rest of Pisa Moorings, which does have that traditional large lot feel to it.
Thank you. The planning evidence for submitters, I can't recall if it's Ms. Mackay or Ms. Pluston, raised a concern about cumulative effects of the various breaches. Have you had an opportunity to consider, in your view, whether cumulative impact is a matter of concern for us?
Well, I guess, the more rules you breach, the more, potential cumulative effects there are. In my view, a development of this nature with, 6 units, you are bound quite often. You do trigger 5, 6, 7 resource consent rules, which could always lead to that potential cumulative effects, outcome. In my view, the rule breaches are all relatively minor in scale. For example, the high breaches, I would say extremely minor. The setback breaches, yes, we are breaching the 15-metre setback in relation to the lake margin, but we have the mitigating factor that, the lake margin isn't hard up against the property boundary. So, when you balance out all the rules which need consent and the effects of those breaches, I don't consider, cumulative effects to be adverse.
Thank you. And in terms of weighting, what's your opinion in terms of the ODP provisions and the PC19 provisions?
That's a great question. I think Mr. Gardner-Hopkins talked this before, and I completely agree with his sort of summary around this matter. Planning decisions at this time are made in a state of planning flux. And in my view, yes, while we have to trigger rules under the PDP, they must relate to the matters of discretion that the frozen activity status has under the ODP, which makes it quite difficult to comprehend about how you should wait. Normally, I would say, with any PDP process, when you're this far advanced through it, you would certainly give more weight to the PDP. But in this instance, because we have that frozen activity status and we are locked in with those matters of discretion, we almost have to give more weight to the ODP in this particular instance. So, yeah, unfortunately, it's not a straightforward answer, and I still grapple with that myself.
Mr. Gardner-Hopkins, in his legal submissions or representations he gave us, basically told us, if I understand it, that both sets of assessment criteria are very similar. In fact, he conglomerated them. So is there really a distinction there?
No, I guess there's not. And yeah, that was really helpful to have sort of the, matters of discretion and the operative plan and PC19 side by side. Essentially, in my view, they are the same. So then, once again, do we need to give much consideration to the weighting? It does become a bit more of a moot point, you know, at that particular point in time, I think, yes.
Sure, thank you. And putting the matter of weight aside, in terms of the policies, the objective of LLRZ02 and the relevant policies to precinct 1, could you just speak to your overall analysis finding in relation to consistency or otherwise with those key policies?
So sorry, that was LLRZ02 objective, yes, and then the associated policies.
Yes, thank you.
Yes, so in my view, the objectives and policies are relatively similar, just more modern wording of the operative objectives and policies. You know, the wording, you know, for example, the first point under the objectives contains predominantly low-rise and detached residential units on large lots. In my view, the word predominantly does not exclude, you know, some higher forms of density. And I do note the overall site coverage, I think, is 30-something%. So once again, it comes down to, well, what is, you know, low rise and, you know, people's perception of detached and open space. Yeah, point 2 maintains a predominance of open space over built form. Well, arguably, and I would say that because the built form is just over 30%, you know, the site as a whole is predominantly open space. Yes, some of that is access, but access, you know, can function as, you know, open space. It's a viewing corridor. It's not established by built form. So in my view, it's certainly consistent with the policy. There was, sorry, the objective.
Just on that objective.
Yes.
The chapeau of the objective reads the large lot residential zone as a pleasant low density living environment. So that is the objective statement.
Mm-hmm.
So are you saying that the proposal is consistent or inconsistent with that?
Overall, I would say consistent. There are probably, you know, elements of perceived inconsistency. And once again, I'll just go back to my point of, you know, what is low density in this context. I would say a development with 30% building coverage can be perceived to be low density, especially when you have the provision of open space and road setback compliance.
Thank you. And in terms of the key LLRZ03, precincts 1, 2, and 3, what's your view there?
It provides for the maintenance of the amenity and character resulting from existing or anticipated development in these areas. So once again, this is where there's a bit of conflict between PC19 and the provisions of the operative district plan. I would say because the application was lodged under the provisions of the operative plan with that frozen activity status, with the RD activity status, we could say, well, at that point in time, the development proposed by way of this consent is an anticipated development. Yes, there are elements of non-compliance, but the multi-unit development rule within the ODP essentially did allow for way more intensive development compared to what the provisions for PC19 say. But yeah, when you look at the application as a whole and balance it, and the fact we have that frozen activity status, I would say the amenity and character of the area will be maintained. Yeah.
And in terms of the key policies, is your view that they are consistent overall or inconsistent?
Consistent overall.
And what's your understanding of what's anticipated under the comprehensive development policy? How does that differ from
you have
proposal in front of us?
you have to have a certain land area to qualify for that rule, which is So, yeah, for large lot residential, the application site is greater than 2 hectares. So essentially, if you have a site of 2 hectares or greater, you can apply to be a comprehensive development. I've actually got one with CODC at the moment, and the 1,500 metres squared averaging for that rule. The 1,500 metres squared averaging for the rule also takes into consideration roads across the whole site. So in fact, you can have allotments down to 600-700 metres squared. We actually have some down to about 500. And then around the periphery of the development, it is much larger. So I guess that rule anticipates, you know, a more thought out, comprehensively designed, large scale residential subdivision compared to this.
Thank you. Great, thank you. And in your supplementary evidence, I'm just interested in the your comment around the land covenant. And it was a question I put to Mr. Gardner Hopkins as well, in terms of what your point is with regard to that.
Yeah, I think I just made that point because it was a point raised in submissions or evidence, I believe it was. And it was a general observation that, you know, I would say 90% of resource consent applications that get lodged within the district and Queenstown would have some form of private covenant on. And the general accepted practice by council is sometimes they include an advice note saying, oh, FYI, there's a private covenant. But yes, it should not be a matter, you know, should not be an RMA matter to consider whether consent should be granted or declined.
Thank you.
Well done. I haven't got any more questions because I had similar ones, but probably just going back to that objective 2, it's RZ02, the reference to low density living environment, and you were asked a question on that by a fellow commissioner, and I took the way you answered that was more to do with maintains a predominance of open space over built form, which you translated to a coverage requirement. You basically said it easily complies with the coverage, so it meets that low density thing. But are they different things? Do you think, like site coverage and density are different things, aren't they?
Yeah, absolutely. Yes, I would certainly agree with that statement. You know, in my view, the objective is it's general wording. It's low density. You know, it could even depend on the topography of the site. You could have a really steep site with a lot of land area, but because of the topography, once you actually build on it or build into it, the perceived density may be greater than it actually looks on paper. I think in this instance, you know, because we have a relatively flat site with open space, with the access, when you look at the site as a whole, there is going to be that open space on the site. Yeah, so I guess that's where I was coming from.
Yeah, so the density, like you could, for example, have 38% coverage with 2 big dwellings. We talked about that earlier.
Yeah.
In the site, or you could have 6 units, but the building form might be the same, but you've got 6 lots of families, you've got 6 lots of cars, you've got potentially more noise. So they're slightly different things, aren't they? It's building form and there's activity.
Yes.
And so
I 100% agree with that. Yeah. So I think, you know, from a permitted baseline point of view and what can be expected, it would be 4 separate habitable buildings, you know, your 2 main units, your 2 minor residential units. So you have 4 families versus 6, completely different. But also, you know, families, it could be households, it could be, you know, seasonal workers, it could be, you know, intergenerational families. It's really hard to define and assess, you know, who exactly is made or who is comprised of a household.
right, okay. And look, you've covered most things. Just one other thing was the previous consents that have been processed on the site, and we asked that question in a minute. You know, how are they relevant? You know, and we have Mr. White provided quite a lot of detail on that. So thank you, Mr. White. But and we fully understand that we're not bound by anything that's happened here. But if I recall, and Mr. White can correct me, there was an application for 2 units which was declined. Is that correct? Or?
Yes, that was the most recent one, I believe. And there was a statement within that consent decision about the commissioners would have granted it if it was just a land use. It was a subdivision component. Okay. They declined it on.
Right. Okay.
Yeah. But I haven't given too much consideration or thought to that. It's lapsed.
That's
well, I never granted. Yeah,
there's certainly no a baseline, or there's nothing that we can use as a baseline from those decisions.
Agreed.
And then I guess we did discuss earlier the 15 metres, and we understand how it applies to the boundary adjoining a lake. We've made a point. Setback, yeah. And I was interested, and I had an interchange with Gardner Hopkins about whether the 15 metres anticipated that there is a buffer, and you know, he said that his answer to that was that the buffer strip would vary in width, and I'm just not sure if you turned your mind. Is it uniform width?
I certainly have, and this was something I think I possibly raised with Mr. Gardner Hopkins last week or the week before. Essentially, if you had a boundary and I think one of the subject sites, yes, it is adjacent to that boundary, but that part of the boundary is so far north of the actual lake margin now. You know, if you could have instances where, you know, there could be a 100-metre boundary running inland from a lake, wouldn't be very common, but you could have instances where the boundary is so long adjacent to the lake, and inadvertently, I think that 15-metre setback would apply from that boundary. So you could have instances where there could be a 100-metre setback from the actual lake margin. I also note that lake margin isn't defined in the plan. So then the question comes down to, well, should the boundary actually directly abut the lake margin for that rule to be taken into consideration, or is the fact that the lake margin is contained within that portion of land sufficient for that rule to be triggered? I think the way it's worded is if that land contains any lake margin, you have to apply the setback from that boundary. Yeah. So, for example, Marsden Resort, if the boundaries were, you know, wider out further away from the lake, I would still say that further out boundary, you have to apply 15-metre setback and assess that.
So you agree with him from a planning point of view that there's a variable distance around the lake. It's not just 15; it's nothing, and it's potentially 100.
Correct. At the very minimum, it could be 15 metres. It could grow, you know, to you know, some huge distance.
Right. Yeah, no, look, that's useful to get to backing this discussion up with planning assessment of it. That's useful. So thank you. And I think we can move to so most of my questions, so that's fine. No, look, that's excellent. We haven't talked about conditions at this stage, but and I must stress these are recommended conditions in the event that consent is granted. We won't discuss those right now, but we'll probably discuss those with Mr. White and then potentially come back to you after that discussion. So thank you. I think we're finished for the morning. So thanks everyone for your patience and indulgence. We'll take a break, and as I say, we've got a relatively light afternoon. We've got 3 submitters coming in at 2 o'clock and thereafter. And then we've got time to do another site visit, which we probably will do. So we'll see everybody back there at 2 o'clock. Thank you. Okay, thanks folks. We'll reconvene the hearing, and thank you to the applicant for presenting your case this morning. I meant to ask Mr. Gardner Hopkins whether there was anything else he wanted to add. He's not on the line at the moment, so
Just popped on.
he is. Oh, okay. Mr. Gardner Hopkins, if you're on the line, I didn't give you the opportunity to recap or summarise anything that came up this morning as the agent for the applicant. You're welcome to do that now if you wish, before we go on to submitters.
Thank you. Look, there's probably not too much I need to say other than I think the discussion that you had with both myself and the witnesses was very helpful. And I've tried to keep something of a running list of things to address and reply, but it might be more efficient, you know, if at the end of the hearing we circle back and we deal with all matters arising at once, so it is clear what I intend to address. And if I've missed anything, or if the panel had something that else in mind, we can deal with it then.
Yeah, that's fair. We are likely to have some specific matters we want you to raise or address in the right reply. So thanks for that suggestion. We'll do that. All right. We'll move on to the submitters now. Thank you, Mr. Vermeulen. Is that you online, Mr. Vermeulen?
Yes, hello. Hopefully you can hear me clearly.
Yes, we can. Yeah, thanks for coming on. Mr. Vermeulen, you and Joanne Edwards have lodged a submission, and we believe that your place is at 10, number 10, Marion Place. Is that right?
10, correct, yes,
Yep.
which is directly opposite the development, looking directly out over it. So, yes.
Yeah, and just to be, commissioners, we went to the site yesterday and we saw a house either under construction or nearing the end of it. Is that your place? Your place
That's
under
correct, yes.
Yeah. Oh, good.
That's correct,
So
yes.
you may have seen us there, but yeah, no, thanks. We understand where you are now, and we've got your submission, and we're in your hands. You can address us as you can either read the submission or talk to it, whatever you prefer. So,
Okay. Now I was going to read the submission in the absence of my better half, who's just clicked on at the bottom. So given that she's a better speaker than I am, could I pass you over to her, please, and she'll read off our feelings?
No, that's absolutely fine. So yeah, thank you for coming on.
That's great. Thank you. I'll pass you over to Joanna. Thank you.
Thank you.
Good afternoon. Can you hear me okay?
Yes, we can. Yes.
Thank you very much for this opportunity to speak, and I assure you that we are going to be as brief as possible, and hopefully I'll stay connected. My name is Joanna Edwards, and we are currently building at number 10 Perion Place across the road from the proposed development. As one of the most recent builds in the area, as you pointed out, we were affected by the Plan 19 zoning changes in terms of where our house was positioned on the section. So we also applied for resource consent so that our new home was similar to all of the other homes in the area. So to maximise the view, we incorporated a large window into our plans to take in the ever-changing views of the mountains on the east. We never did envisage looking out onto a 2-storey apartment block with multiple vehicles and multiple tenants, and then multiply this by another 5 of the same. That was quite a surprise. And then the fact that it's shoehorned onto 2 fairly prominent sections on the corner that I believe were originally designated for single level dwellings. So 2 houses, not 6 2-storey houses was probably what we were expecting when we decided to build there. We really like Pisa Moorings. It's gorgeous. It's a low density feel of a neighbourhood, the careful planning that has integrated the Keystone waterfront units within the subdivision, the allocated parking that belongs to the units, which was factored into the overall planning, that allows the neighbourhood streets to be relatively unaffected by any overflow of visitors. It's the feeling of space and openness that the neighbourhood provides that is the attraction of when we actually will live in Pisa Moorings. It is the existing semi-rural residential zoning that was the appeal, basically, of moving to this part of Cromwell, which is in stark contrast to some other higher density subdivisions within the area that would have been a bit of an adjustment for us after living on a lifestyle block in Southland. We believe the proposed development is not compatible with the character of this area. We believe that no shrub, tree or fencing or other landscaping elements would be up to the task of reducing or disguising the block effect that the height, bulk and density of these proposed units would generate. Because the section is very prominent on the corner, it's almost a gateway into this whole Pisa Moorings community. The scale of these proposed units, I believe, would adversely visually dominate the site. And we believe that it could be to such effect within the scale of this development that it may potentially develop the homes of all of the residents who have followed the council's previous regulations and built their homes within the subdivision, not to mention detract from their lifestyle with the addition of multiple, possibly temporary or transient residents occupying dense housing on such a small site, a site with limited parking that would almost by necessity have to overflow onto the side streets of Perium and Foster Place. On one of the last remaining Pisa Moorings sections, surely the rezoning template, should not be applied to a neighbourhood that has already been almost fully established within the previous zoning regulations. It does appear to us that this development is an opportunistic move to exploit a change in the zoning regulation that was not factored into the existing plan of the neighbourhood. And there is a reason for that, as it would have detracted from its semi-rural character. And I could say that it's nothing personal, but it is very personal because we intend to live here and we will be affected by this decision, as will many other residents in the neighbourhood who oppose this development. So in summary, to use the appropriate wording, the number of proposed units and the height of these proposed units will affect the level of openness. The dominance of built form will disrupt the existing sense of spaciousness in the area, and we believe the proposed development is incompatible with the character of the Pisa Moorings area, which we would like to preserve as is. And thank you very much for your time.
Very good. Thank you very much. Well, just we'll have some questions for you, if that's okay. And I noticed were you reading from a statement there, Ms. Edwards? Did you have some written notes there as well as your submission?
Yes, I did have some written notes, which I put together last night.
Is it possible, they may be handwritten, but is it possible for you to send those through to Ms. Lyons at Council, just so we have a record of that? It might help us when we come to consider all the matters again. Thank you. And because your submission, written submission breaks down several points, which we've got in front of us now, but I think you've got some other points that we'd like to consider as well. Thank you for that. Now, one of the key points you made was that when you bought this property and built there, you had in mind what could be reasonably expected on this piece of land opposite you, and you've made adjustments to what you thought would be possible. And have you assumed that there'd be one dwelling per site, because there's 2 sites here? Is that what you based that on, or did you imagine there might be more than 2?
No, look, I wasn't really, you don't really sort of plan ahead. They're really nice sections. They look across from us, and we expected to be able to sort of look out and see the mountains, and that there wouldn't be certainly not a 2-story building. I thought perhaps 1 home per section, because there was 2 sections. I didn't really expect there to be any more, but yeah. That's okay.
Yeah, that's understood. Yeah. And the other question I had was, you talked about the change in the planning regime, with the plan change 19 and so forth. I think you said you understood that to be a more permissive or a loophole that might be coming. Is that how you see it, or?
Not a loophole. It was merely that we had to sort of apply for resource consent just to have our house sort of with the same frontage as all the other ones on the block. And having read the PC 19, I sort of understand the gist of making more affordable housing. I understand the reason for it. I just sort of wouldn't have expected it to apply to such a it's largely built. We were one of the few last remaining sections aside from the ones across the road. I'm sort of surprised that it would be encompassed within that, just because it was largely established, the whole area.
Yeah, because the evidence that we've had put to us is that it actually makes things more restrictive because it introduces a large lot residential zone, and in other words, the density would be more limited under the plan change for this site. That's how it's been presented to us, and we're certainly considering that as well as the current planning regime under the current plan. So interesting to hear that. But look, that's fine. I fully understand the points you're making, and I'll just see if my colleague has any questions for you.
Okay. Thank you, Ms. Edwards. That's a really helpful presentation. Thank you very much. And my question for you relates to the existing environment, and we have heard evidence today around the higher density of the Marsden resort and the cafe and the car parking, and that perhaps represents a more urban character. Clearly, you're seeing that quite differently. Would you?
What? Sorry.
Yeah, no, you go. You respond.
Well, what I see, like from where we're facing, where our house faces, is there is, like we're facing on the right hand side car parks, and they're largely empty, to be honest. But there's sort of landscaping, and there's a feeling of openness when you drive in there. And because we're sort of at the top end, we sort of see things probably slightly differently, perhaps, than the people as you go down Perium Place. It just there is a feeling of openness, and albeit there is 2 empty sections, of course, so that probably enhances that.
Yes.
As well. But I don't see that as urban. I feel that the waterfront units were originally planned for, and they've been beautifully done the way they're sort of staggered around the side. I believe that was all factored in at the time, and it sort of makes a difference that they have also allowed for parking. It was actually built into, I believe, the original plans of that area. So they've taken that into account. They haven't tried to add a little bit extra onto it. And from what we see, like it's a really lovely subdivision. I don't know, it has got a semi-rural feel compared to some of the other ones, and we've been into some of the other ones in the area. It just feels very open and expansive, and I don't know whether I would say it's urban. Well, I wouldn't classify the waterfront units as urban just because of the way they've been designed. They sort of, yeah, that's my opinion.
Thank you. That's you've articulated that very well. I was just interested in your perception of the existing environment and how this proposal is aligned with that or not. Thank you.
Thank you.
May I also speak in to that?
Yes, certainly.
Thanks, Joanna. When we purchased the section, it was a few years ago, and at that time it was under a different rural plan where all the houses were under the original concept. Joe's correct. We had to apply for resource because it came in under a large lot development and a change in November, if I'm correct, previous, and it encompassed the same sort of rules as ruling as Wellingtree, which is a high density urban environment where you can almost touch the house next door to you. I don't think the original concept in Pisa Moorings was to have that type of urban development in Pisa Moorings. We would never have purchased a property there if we knew we were going to live in Wellingtree. The proposed driveway is directly opposing where we're building, and we're going to be impacted, if not the most or one of the most severely ones in the whole development. I'm not convinced as to what their reasoning is to take two sections and put 6 houses in there. I don't think it's an urban thing. I think it's probably more of a profit-driven thing. Good luck to the developer, but I don't think that's in keeping with the rest of the development. And Joe says it's a little bit unfair to apply those rules at the end of in the last 2 sections of the development, whereas everyone else has already complied and will have an effect on them. These people who are doing the development, I don't anticipate that they're going to live there, but we are.
Yeah.
Thanks for your time. Sorry.
No, that's fine.
No, yes.
No, look, thank you, Mr. Vermeulen.
Thank
Ms.
you.
Edwards. We understand what you're saying, and
Thank
thank you very much. It's great. Thank you.
Okay. Thank you.
Thank you.
All right. We'll now go to Mr. Naylor. You're here in person. Yeah, that's me. Thanks, Mr. Naylor. Come forward and wherever you want. Just here. Yes, yeah, thanks, Mr. Naylor. We've got your submission, and we've got a tabled statement that you sent in as well.
Yes.
And first of all, before we start, we think we understand where you are. You own the properties, more than one property, on the corner of Perium Place and Foster. Is that right? Perium Street and Foster. No.
We're 8A.
That's the next one. That's the next one. Sorry.
Okay.
Okay.
We're the closest unit on the eastern boundary.
Oh, is that right? On the eastern boundary. All right. So that's fine. Sorry, we've got that wrong. I confused that with the next bit. That's all right. So yeah, we've got your submission, and how do you want to read that out? Or do you want to
I'm just going. I've made a few notes in the last week or two, just for all the information that's come in.
Right,
Obviously, you've read my submission.
Yes,
I'll try and not repeat that.
that's fine.
Yeah. But anyway, I'm Travis Naylor. My wife and I reside at 8A Foster Place. I'm also the Body Corp chairman for all the villa owners, just incidentally.
Okay.
I'd just like to say that we keep reading in the council reports and expert testimony that written permission has been obtained from the Marsden Residents Association. Now, I can categorically say that there is no such association there, and that the only legal entity that can speak on behalf of all the body owners, all the owners is the body corporate, of which I'm obviously the chairman.
Yeah.
This so-called written approval does not exist. We have repeatedly asked the council to retract the statement, but nothing has been done about it.
Yep.
And I feel that this statement has tainted the whole consent process so far, with experts continually referring to something that is untrue and does not exist. Due to this incorrect statement, the body corporate, as immediate neighbour on 2 sides of this proposed development, hasn't had the opportunity to speak for themselves or on behalf of the Perium Cove villa owners. Now, I'm not opposed to the owner of the 2 sections building something within the council rules, but these sections are zoned residential. They are not zoned for commercial development like 6 units
by a speculative developer. In the expert evidence submitted, they talk about a transition area. Well, I don't know what they're trying to transition to, because all other sections on Perium Place and Foster Place have a single dwelling per section. Now, 6 units on 2 sections is considered a multi-unit development, which according to the rules requires a minimum area of 2 hectares of land. The developer states they want to transition from a high density development, which is us, to the lower density being the homes on Perium Place and Foster Place. But in fact, if you look at us as an example, we have 2.6 hectares of land for 24 dwellings. This equates to a build density of 1 dwelling per 1,107 square metres. This developer with 1,941 square metres wants amassing of 1 dwelling per 323 square metres, the highest density in all of Pisa Morris. Now, much has been said about 15-metre setback. And if you read the rules, all sections bordering the lake have a 15-metre setback from the front of their section. Now, one of these particular sections, number 11, was for sale about roughly 8 or 9 years ago. I know this because I looked at buying it. Now, during my due diligence, I took all my plans to the council and I was told by the council there was a 15-metre setback from the eastern boundary of the section. Hence, I didn't buy the section. As far as moving on, as far as privacy issues goes, units 4 and 5 appear to have first floor outdoor dining areas that appear to be approximately 1.3 metres above ground level and face directly at our living area. Now, we're all glass along the front of our unit, so we've got nowhere to hide. I know what a fish in a fish bowl feels like. The empty sections as they stand at present are well above our build. In fact, 9 Perium Place, ground level is roughly the same height as our 2nd story floor. So a build height of 8 metres above ground level will tower over us, not to mention the angle of unit 3 and 4 will almost completely destroy our view of the Pisa Range. Now, the council rules state that a build height cannot exceed 7 metres. Those sections are raised well above road level. Maybe some thought should be put into, given to excavating the high points of the building site. Moving on to shaving. The close proximity to the boundary and the new rotation of Unit 5 will create all-day shading of the walkway during winter months. This creates a slip hazard for locals and hotel guests alike. The suggestion of vegetation 8 metres high on the southeastern boundary will only exacerbate the problem. And that's enough from me.
No, that's good. Please, maybe while I ask you some questions. First of all, I'll just clarify that the written approval, and that was clarified today by Mr. Dunn. I think we said that there is no written approval, so it's been confirmed today. So I think you're correct there.
Right. I think some of the owners feel that there hasn't been enough weight put towards their submissions because it just keeps turning up in all the documents.
Yeah, that is fine.
And some of the expert evidence, I think, including Ms. Dunn, were, what was her name?
It was on today. Or?
It was on this morning. What's that lady's name?
We had
what's her name? Eaton.
Oh, yeah, she hasn't come on.
She hasn't come on.
No, she
I think in one of her things she said states that.
Yeah, that's right.
Because we've given written permission, we forget about our submissions. But
we'll test that with her because she's on tomorrow. We'll just put that to her. And
okay.
So thanks for raising that. You're going to follow up with something.
I was just going to reassure you that we've been tracking that issue through the process,
right.
And that's been confirmed that wasn't in fact in existence, and we will look at all the submissions and all the issues that are raised across all submissions. So the process has,
thank you.
It's all come out in the wash in that sense.
Thank you. You're on the committee or the board of the resort, aren't you? The residents.
Chairman of the body corporate, which is the owner of all the land.
It's quite handy
on two sides of the development. Yes.
So that point you made about it being quite low density because you've got a very large site area.
Yes.
Hectares. Does the site here include the lake itself? Is that part of the complex or?
Yes,
Yeah, it must be because it looks, on the face of it looks high density, but it includes all of that land.
includes all the car parks out the
And the
back.
car parks, yeah. Okay.
Yeah, and that land on the east side of the development,
Yeah,
that's ours as well.
okay, that makes sense.
Thank you, Mr. Naylor. So you were particularly concerned about the potential privacy issues on units 4 and 5, is that correct?
Yeah, just with the rotation of where they are, they appear to look directly into the front of our unit.
Yes, and your unit is this one?
That one, yes.
Great, okay, just making clear. All of the numbers have been quite tricky to work out. They're very different. They're not kind of translating to.
I actually see in the submission, some of the owners got their own addresses from.
Yeah.
Yes.
Yeah.
So it's great to have that confirmed today. And so is it in particular, what you're saying is that the elevation of that site combined with the height and the balconies, you're concerned that that will directly impact your privacy?
Yes.
Okay, thank you. Thank you.
We'll go and have another look. We've been to the site, but we'll go back and look at it specifically from that point of view. So it's good to raise that with us. I think it's probably all actually. You made some point about the 15-metre setback. I just didn't quite write it down in time. What was your point there about the 15-metre?
Well, I tried to buy one of those sections previously.
Oh, yes, okay.
I looked at buying it and I went to the council, I did my due diligence.
Yeah,
And they told me that there's a 15-metre setback from the edge of the section.
yeah,
So that was the main reason I didn't buy the section.
right. Yeah, that's as we've been told, a lot of these standards like height and recession planes and all the other things, setbacks, an applicant's able to apply to have them reduced. And I guess the question from your point of view is it a reasonable reduction, a reasonable to have 15 metres, should it be applied here or not?
No other section, no other build in the whole Peas and Moorings development has got closer than 15 metres from the front of their section.
Right, other than the resort itself, yeah.
Well, yeah, we're 2.6 hectares and
Yes,
we still have 15 metres in front of our units.
right,
It might have a bit of water over the top of it, but
okay.
we've still got it.
No, that's fine. Thank you so much for coming along.
That's all right.
Thank you.
Thank you.
Thank you for your time.
Okay, thank you. All right, we'll now go to Perium. Perium, thanks for coming along. I think I've described the properties you've got already. But yeah, we're just trying to understand. I'll let you get seated first, sorry. You've got the corner property, which has got a dwelling on it, and there's some vacant sections next door with driveways sort of start possibly being installed. So maybe you could just explain to us what's happening there, or what's intended there before we get started.
Sure, I'll just make myself organised.
Yeah,
And,
organised. Yeah.
please be aware of, just got a wee ear infection going, so I'm a bit half a hearing, hard of hearing, the other half blind, but that's okay. Look, yeah, thanks for giving me the opportunity to speak. We are well affected by this proposition. Bob Perium and Robert Perium. You've got my submission there in front of you. But I just want to, at the early stages of this, just realise that there's been a wealth of opposition against this. And this has been going on for a long time. Submissions closed in August last year. But the same people tried a very similar application in 2019 as well. And are you aware of that?
Yes, we've had, we asked for a report on that, so Mr. White has produced that.
I just want to press first on council more about the feeling, particular residents on Perium Place. Look, I reside at 1 Perium Place. My partner is Nicola Adlam, another submitter who I'm representing here today as well. I live on 1 Perium Place. I own that property as well. A number of the people down Perium Place had come to me because I am the original Perium, that put the Perium in place, and they're wondering what to do about it. I've had Lana, she's one of the opposition submitters here too, in tears because she got 2 little kiddies and just absolutely didn't know what to do. So, I said, okay, the submission process, I'll help you through it. But you've got to realise that this has gone on so long now. There's been a war of attrition, but where they just can't be here today because basically they're over it.
So I feel like, it's a wee bit unfair. I feel like at the start, that feeling went into the submission process to council in August of last year. We never heard anything back. Never heard anything. And then I got on the phone to Travis. I said, Travis, what's happening? He said he didn't know. Rang the planning department. They said, we won't talk to you. And then another month goes by, and people's feelings and livelihoods are at stake here. They really are upset about it. So I would urge that process to be more clearer competition, more transparent, and communicate with the submitters in a better way, because that's just not fair. Just clearly, I just want to make that point starting.
No, fair enough. And I would point out we're well aware, I think there's 20 or 22 submitters in opposition. We've read all those statements, and we've also got some tabled statements from Lani McDonald and Margaret Sanchez who aren't coming, but we've got their written statements as well. So,
yeah, Lana's one one.
Yep. So we'll fully consider all of those matters.
Good. So referring to my submission in front of me, I'll just go basic points as I'm also the owner of lots 1 to 4. You referred to that plan before. You'll have that there. I also went on board with a joint submission with the unit holders. I want to be quite clear with Jo Appleyard. She's back tomorrow, I believe. So I was part of that submission as well when I signed that submission. So my submissions were 2 times plus Nicola Adams.
Very good. Yeah.
We are opposed to the application and its intensity. Now, you've been hearing about that and the intensity and well spoken across the road there. And then it was a challenge about is this a unique rural setting, or is it an urbanisation? Now, I can speak as property owner for the land across the highway too. I join the highway and all farmland there, and I reside right beside this application. I can hear my lambs barring, 300-400 metres away to the west, and then to the south is open space. And please, if you're coming out for a site visit, I can only encourage to show you around the area, and because I do have local knowledge, should you wish to.
We'll probably be okay just driving around. We've actually done another hearing nearby, so we'll just have a look around. But anything you want to point us to today, we'll take on board.
Yeah, I'll be at home anyway again.
Okay. All right.
So I refer back to an application we did in recent times. It was only, we subdivided 4 lots on Foster Place. They were very large lots, but the 4 lots ended up being 850, 850, 850 and 877 on Foster Place. And they are not correctly in the referral to here. They are lots 1 and 1A, 3 and 3A.
Yes.
To be correct in the system there. When we did that, we went through a notified application. We had 1 submitter, and we kept the big thing that we did. We kept it in general integrity of the area. Now, one thing, we had the planner come out, and one thing when he spoke at our hearing, he talked at length about the integrity of the area. Integrity meaning 1 house on 1 lot, and when open space, when you've got 1 house, you've got this frontage on the Foster Place and Period Place, and he considered that we were not in breach of any of that integrity. I thought that was a really good word to be using when we're actually talking about a different concept altogether here. We're breaking that integrity by having an intensive subdivision investment into 2 residential lots. I've also got here. I won't keep finding things for better of. But in our planners report for our subdivision, there was a special note to the turning down of the applicants back in 2019, and all the reasons why. Now, they're all stipulated in that document, and I hope you're
aware. We have got all that information.
Because I've done that with my planner just recently, and it's not hard to putting big documents on the table, but he was very, very clear that of all the reasons why that should not go ahead then. And can I please just make a point that that was a single story and lesser incumbents on the environment than what
Two
we're
dwellings,
looking at now.
was that the one with 2 dwellings in total?
Yeah.
Yeah, we did hear something about that, but we're going to ask Mr. White some more questions. But can I just ask before we go on, why did you need resource consent for a large lot, 850 to 870? What was it created?
Because the district plan, it was in the old one, it was residential marina zoning with the minimum allotment size of 1,000 square metres.
Okay.
But in saying that, my direct neighbour is 900 square metres because what the developer did, he averaged it over everything.
Right.
And so all my adjoining neighbours along the inlet are 900 square metres, so 850, 900, very much in keeping with.
So residential marina zone. Yeah, okay. We haven't heard of the residential marina zone, but is it what?
Yes, well, I am the original owner of it and I put that zoning on there. That was original zoning.
All right. Thanks for that. No, understood. Thank you.
Look, on B, I mean, C, it's a breach of the height plane. It is not tolerable and it will directly affect our views to the south and the east of the land. So that's a given. It's been repeated time and time again. I'm totally with that and it'll be spoken again tomorrow by Joe. So
yes.
I've witnessed over time where covenants in the titles of the original development are breached, such as setback from the roadside. And it doesn't seem to be anybody following up and making sure that everybody's, say, 4.5 off the front roadside boundary, for example. And there's a prime example opposite our pub. We've just gone up recently. It's virtually right on the footpath. Now, the question here is who is monitoring this? I mean, how come that happened and how come building consent was issued for that to be allowed? When that's done, really alarm bells ring for me that the next development will do the same and lose that precedent. So I'm very concerned about that. But I go forward to say the 15-metre setback from the lake is something I know a lot about.
Okay.
I am at the moment building a new home. We're due to pour concrete on Friday. And here I am thinking we applied all our footprint of our house exactly with the 15-metre setback off the lake.
Right.
And I'm thinking, what do I do? Do I cancel a concrete truck? Do I wait for a new precedent to be set? Because, that will set a new precedent. And I think it's a shame. I think a lot of people will be upset. And when you come on site visit, I would love to show you the inlet over where that's all been applied. You see beautiful setbacks from their boundary, gardens, and then a nice mown strip down to the lake.
Yeah.
And part of what I'm doing, and I needed a resource consent to do it, is in keeping exactly with that. So
yes, I've been for a walk. I think I know what you mean. I've been for a walk down to the lake edge when I last stayed.
where's the boat ramp down there?
Yeah, that's right. And you're right. It's just very open. There's grass, big lawns that open out. Right.
Yeah, some weeping willow trees.
And so you're building a house down there. Is that what you?
Yeah, I'm building at the top of that inlet. Yes.
You're going to be 15 metres back.
Yes. So, like Travis, he mentioned about in the past, everybody's had to abide by it. It's affected the property values in the past. I too abide by it, and I can't see why this should be exempt. I really don't. There's a lot of good reasons in there. It's about protection from future flooding. There's protection about giving a rural space around the lake, and all those things. When you see where people have developed, it's been successful.
Okay.
So I refer to the plan there, where this is going to be breached, and the development I'm referring to is down the side there.
Where did you get that plan from? Was it from the
That comes from the recent application.
Yeah. Thank you.
But we're totally opposed to that. Another part of, and I don't know if I've got a map here, I do have a map somewhere, that I don't know whether it's been put on the map, but when we went through our application, we have one submitter opposed because there's a flood zone over all this land that is up for application. Have you seen that? It's on the maps of the Otago Regional Council.
I haven't seen that.
And so we had to navigate through that. Our foster place land is considerably higher than the applicant's land. And I wish I could show you it is in the depths of these files here somewhere. But if that hasn't been tabled by now, you need to be aware of it because it's in the current maps of the Otago Regional Council floodplain there.
I might just pause and ask Mr. Whitehouse, put another task on you, if you don't mind, when you come to see us tomorrow, if you're able to follow up on any flood zone hazard notations or anything that affect the site.
I'll be able to help you after the submission, after I speak. If
You can hand it.
find it somewhere. Yeah.
Fine, that might help. Thank you.
On E, the plan show car parking and garages included, but these will not cater for the potential capacity of 4 different couples per unit and 3 units per title. I've witnessed also many times in my time as the development of the existing units where Travis is, and he represents those. And it's just sad to me to say that when an application is made showing these off-street car parking within the buildings, as soon as it's all signed off, all the unit holders, or many of the unit holders, took advantage of turning them into bedrooms and gaining more revenue from the managed business part of their. So all that end up on the street. I will say the development had a very generous amount of car parking anyway, but these guys don't. And it's a real concern if I go to a layout of the main concern is the layout here of this development, where they turn out onto Foster Place.
Yeah, it's actually changed since that. They provided an amendment. I can hand this over to you if that helps, but there's been an amendment to design. It's still 6 units, but they're just orientated slightly differently. Yeah.
It still goes out to Foster Place.
Yeah, but they've got essentially 1 garage car park per unit plus 1 in the driveway. So there's two parks per unit. Is what's presented.
Right.
Yeah.
So you can see my concern where I am, that parking alongside of Foster Place is going to create a very blind corner there between the corner of Perium Place and Foster Place. There's very little. So I don't know what the roading people are going to make that a no parking zone.
Well, thanks for raising that, because we've got the traffic engineer for council tomorrow, so we'll ask him that question. Thank you.
And one thing that, look, there's been that many reports circulated. Look, I'm guilty of not reading them all, but one I wrote about the traffic side of it on behalf of the applicant, and he was saying that the effects would be minor. As I read through that, there was no mention of where the school bus route is, and the school bus stop. Are you aware of that?
We're not. No.
Okay, it's directly opposite me in 1 Perium Place. So they walk down Perium Place right across this intersection to their homes at the end of Perium Place. And I thought, now that was a wee bit devious of the report writer, when in actual fact he didn't even live in the area. Trying to tell us, someone that's been there since day one, that the effects on the residents and the traffic flows will be minor. So I do take exception to these expert witnesses. They come up with a sort of.
Right, so just so we've got, what's your concern about where the school bus stop is? What are you concerned about?
Up from the main car park opposite.
Right.
1 Perium Place.
Yeah. It stops here and what?
It does, but it does a big turn, yeah.
Right.
So when you're on site visit, you might like to see that.
And what do you say about that? Do you say it's unsafe or dangerous, or is it not the right?
I'm really concerned about parking on the side of the road of Foster and
Parking. Okay.
will create blind spots
Okay.
for little ones crossing that road.
Okay. Just needed to write that down.
Where currently now it's got very little parking on it.
Okay. That's a fair point. We'll put that to the engineer. Thank you.
And lastly, if I'm very concerned about the new intensive activity, there will be a change of integrity. I use the word integrity at a time, to our unique, peaceful, safe residential feel, and currently have and hope to protect it. Please note there is very little
no sections available. It's already been built on here, and it's been mentioned today. And this would change this. We note, please note I have protected any type of multi-development happening on all my remaining sections of the place. Now I've put covenant notes here to my titles. This is totally voluntary because of my integrity to the area, and we've got strictly not to subdivide any lot any further, or unit title, any development, or make any boundary adjustments to my 4 lots. Not to put in place any cross leases or similar lease structures or any lots. Not to undertake any business activity or that would burden the land. So these are some of the things through my lawyers that we voluntarily put in place. So some people, say things but don't back it up, and I just want to make sure I give you supporting evidence that we have done that. So
Thank you.
we are severely affected by looking straight across the top of it and traffic flow.
Okay, look, I've just got just first of all, see if my colleagues have any questions. Let's see if we've got any questions.
Thank you. That was one of my questions for you about what your intentions were for the lots 1 through 4. And you just explained the subdivision and did you say that was a consent notice on the subdivision? What are those controls recorded on?
The covenants on the title.
On the title, right. And
So they're probably, sorry.
Yeah, what's the time frame for purchase of those lots or development on those lots?
We've sold one.
Sold one, yeah.
And to show you how particular I am, we're selling them ourselves. So we're actually vetting the owners. We also vet what they're going to put there, and it's strictly one home, one title.
Thank you.
Okay, I was just going to ask you one more question, Mr. Perry. The transition area. I think you mentioned the transition area. We've heard about that. The applicant is saying that there's the low density suburban area like where you are, and then there's the resort, which is quite relatively high density, and then this site sits in between those two, and they see it as a natural sort of transition to have multi-units on there. But your vision for that site would seem to be just one house on each lot. Is that what? Yeah. So you don't.
Along with that, all else, but
you don't see the need for a transition. You think it should be the same as on the other side of the road, even though there's a road separating it. And there's an argument, and we may not accept this argument, that this site is ring fenced by a road which is related to the resort more than the streets beyond it. Or you don't accept that argument, I presume, or you think it should be developed the same way as on your side of the street. So,
I do, and I think that's a general transition in that way. Look, I don't hold if they want to have a 2-storied house as long as it doesn't breach the pipeline. That maybe it's slightly more intensive than a single-storied house.
okay. Yeah.
But no, I don't see that as complete, needing to be the complete onto the corner of there. No.
All right. Thank you.
Yeah. You obviously have a very close understanding of the environment here, and I was interested in were you involved in the Plan Change 19 process at all?
Yes, it was.
Right. What can you tell us about your observations of the zoning of this area and any insight as to why the mountain resort may be included within this zoning, within the? Yeah.
My understanding is probably quite specific to my submissions. We made 2 submissions. We had one submission to the Plan Change 19 accepted, and that's where I live on 1 Perion Place. Part of it was zoned residential, and half of it was zoned rural. So we've successfully got that to be all included and as rural, minimum lot size 1,000 square metres. We had a plan change. We had a submission across the road, directly across the road, that was turned down, and that was going to be a rural residential. 2,000 square metre lots, about a 20 lot subdivision, and that was come back to us as a soft no, a no for now, but please, come back to us another day. But I do believe this the sewage system is maxed out. That came out in Plan Change 19 to the tune where areas of new residential development were told to have an overlay where they couldn't go ahead until such time the sewage systems and water systems were
up to speed. Yeah.
Thank
So
you.
is that my knowledge of it? Yeah.
Thank you, that's helpful.
Been very helpful. Thanks for coming along and we welcome your input. Thank you very much.
Okay.
Mr. Perrin.
As I say, I can meet you out there if you want to.
Well, we'll see how we go. We may wait to hear all of the submitters and then go out again tomorrow, but we'll see how we go. Thank you very much.
Thank you.
All right. Okay, now I think that's it today. We've got a lot more in the way of submissions tomorrow and evidence. So we're taking an early break now. We'll adjourn. We're starting at 9 o'clock tomorrow. And we'll be on a fairly tight time frame tomorrow with travel arrangements, flights and everything else. So we'll be trying to keep to time tomorrow. But thank you everyone for your input. You're in adjourn.